recording so that we're able to have a recording for those who are not here. So yeah, glad to meet you guys again. I know we've had 2 sessions and I had a few things to do here and there, but I'm glad that now today we are back together and we are going to have this session. We're going to focus on probate and administration. So we are going to go through the March 2023 paper. And I want to believe that maybe you guys got time to go through it so that we have an easy time to, to do it today, to discuss it today from question 1 to the last question. Now, as usual, we always begin with a word of prayer. So I'll start us off with a word of prayer, then we'll be able to begin. So allow me to pray. Our Father art in heaven, Lord, we thank you so much for this evening. We thank you so much for bringing us here. We thank you so much, Lord, for this opportunity that you've given us. The fact that we're able to come here and discuss together and get answers to these questions and learn, Lord, and prepare for the CLD exams. King of Kings, I pray for each and every person who is here. I pray for this, Lord. God, may you open their eyes. May you lead them and guide them. May you walk with them through this journey. And it is in your name that we pray and believe. Amen. Okay, guys. So today, as I've said, we're going to go through the March 2023 paper for probate and administration. But just before we begin, we can begin at 10:40. That is 4 minutes from now. I just wanted to check with you guys. I just wanted to consult you guys and to, confirm with you guys again. Feedback is very, very important. Feedback is quite important. In the next 3 minutes, as you know, we have 3 minutes. Can someone just give us feedback on how this session has been and on maybe something that you'd like us to change on? Apart from that, I know that you guys have requested that we have a session during the week. Now, I'm trying my best to, talk with my team and my colleagues so that we're able to, have these sessions. Again, we don't want to promise you that we'll have these sessions, then we end up not, showing up because there's a lot going on, as you guys, I think, also know at the workplace and everywhere else, and there's so much pressure, but we are still trying to work on the modalities of being able to have these sessions. So any feedback from any of you, anything that you'd like us to change, how the sessions are, how we could make them more beneficial to you, just in the next 3 minutes, any feedback before we start? Again, we are here for you guys. So if you're doing nothing, again, we'd just like to know anything that we can tweak here and there just to make this more productive. Anyone? And of course, you can also tell us how you're doing, how how school is, how everything is, how it feels to prepare for exams and not orals, and the difference. If there's anyone kind enough to share any feedback before we begin, you can just raise your hand and let us know. Again, do not worry. It's a free world. It's a very free world. Michael Mulandi, I think your camera is on. Yeah. So you can put it off maybe. Anyone? Let's cheer up, guys. Anyone with anything to say? Any feedback? Or we're going to say that, silence means acceptance, or rather the fact that everyone is fine, we're moving on well, there are no complaints, and we're fine. And the only thing that we should be working on is the midweek sessions, because that's the only thing I've had so far. I've not had any complaints so far from anyone or any other thing. Anyone with anything to say? Any feedback, any complaint, any suggestions, any ideas?
Yes, Mr. Odward, let me just, it is me, Lual.
Okay, sir.
Yeah, I was suggesting, this session, they help us a lot, especially during our orals. We try our best, and this one has empowered us to prepare for the oral. So we have the same mentality that this one will orient us to do our exam and to show us most of the more ways to tackle the exam question. So my request is to, if you can at least make even two times, meet weekdays, and then in the weekend one class. So if it will be possible, then you try to talk to your team and like those of Angelo, and your team, those who used to be with during the oral mocked. So kindly just try that, because this one is very, very helpful to all the students. I will really appreciate. Thank you. And to comment that it is very this session are very important for us. So you keep doing it as you offer yourself to help your brothers. It is your willing to help us, and God will reward you. Never give up. Then if it is you alone, try your best. If you cannot manage all these weekdays session, you can at least manage 2 or 3. Then it will be productive to all of us. Thank you.
Thank you, John. Thank you so much for that feedback. So I think for you, basically you're talking about the midweek sessions, and you're proposing that at least we can have 2 during the week. Okay, that's a good suggestion. We're working on the modalities of that. We're trying to see how that can work. And I think I just requested to give us this week maybe to continue discussing on the same. Then we can see what we can do. We can see what we can do. When are your exams? Just maybe to consult, or you guys have no information? When are your exams?
November.
And what? We're in September. So you only have October. Then you have
1 month only.
Okay. So I see they're quite needed. Okay, all right, John. We'll see what to do about that. I mean, there's a lot of pressure out here, but yeah, we'll see how we can deal with that. Anne, are you in? Anne, are you in? Have you joined?
Daniel.
Yes.
Can you hear me? This is Anne.
Oh, you're in. Okay, Anne. I texted you. Fine. Thanks. So guys, today we're going to go through this session with Anne, and I'll also just be on standby to help here and there. So we are going to have this discussion, but mainly Anne is going to lead us. So I hope we'll have a good time. And the way we discussed and the way we have always discussed, our role is to lead you towards the right answer. So let's all just try to contribute towards, reaching that right answer. Again, when it comes to the law, what really matters is your argument. Are you able to support the argument that you're making? And so let's try our best to give Anne an easy time. And maybe if you can clap for her as she joins, maybe you can do that. Anne, the session is yours. You can take it away. I'll be on standby if you need anything.
All right. Thank you. Thank you so much. Thank you for making me feel welcome. My name is Anne. Now, you will pardon me, I have a little bit of I'll push this the much that I can. Yeah. So as I said, my name is Anne. I'll be with you guys this evening, and maybe then before I begin, I wish to remind you that the bar exam is not the last thing in life. There's still life even after the exam. So keep hoping, keep trusting, keep working your best. Do the best that you can, and let God bless whatever it is that you'll have done. Now, today we will do the 2023 March. I think, yeah, it was the 2023 paper. Is the one that we will do. Now, by now, I know you already know what the Law of Succession Act is. You should have actually interacted with it. The Marriage Act, the P&A Act also. Hoping you have seen it. The Constitution also has a little bit of play when it gets to probate and administration. Yes. And you should have known when these things came into place, because some of these questions they will be asking will have the ears tagged to see whether you're able to know. Like now, for example, when did the Marriage Act? I don't know whether anyone can tell us when the Marriage Act was enacted, when we started using it. Anyone? Anyone? I'm not sure I can see any hands. All right, none. But you should be able to see. You should be able to know basically.
Anne is breaking, Daniel. I don't know how we will call.
Can you hear me?
Yeah, we can hear you, but you keep breaking. I don't know if it's you. Yeah, could be your mic or something.
Okay. Yeah, sawa. Then what I can do about it. But in case I break off again, please let me know. Now, orals where we are scenario this
Anne, you're,
in this past.
Anne, you're not very clear.
Hello?
Hello, you're not very clear. I don't know what the problem is.
How about now?
Yeah, now it's clear.
Okay. Let's see what we can do. Sorry about that. Again, back to the thing. I'm triple sure some of you have encountered that question during your orals where the panelists gave you a scenario and they gave you a particular year, something like so and so got married in 1960, gave birth to a few children, then died at this time. And the question is basically the mode in which the estate that has been left will be divided to the children. So before then, there was a provision, or there was no provision basically that brought equality, that both male and female children should be partakers or inheritors of the estate of their parents. But now the law is different. So you need to know when some of these acts came into place so that you are not confused and so that you know what is applying when and how it is applying. So let us go to the first question. That is in
And I think someone
question one reads, so I'll read it and then we will have.
Someone can
Sorry?
project it for us. Someone can project it for us so that we're able to follow together. Yeah.
Yes.
But as you read it, that is, someone can just project it for us. Anyone can just project it. Project the questions for us. I think we have Otieno Julene.
Yes, I'm projecting in a minute.
All right, thank you, Jen. Right. Maybe while she does that, we can proceed on to read. I hope that's okay.
Yeah.
Okay. So question one reads, Carrington and a civil marriage in 1970. Their marriage was James and Mary, 1971, and respectively. Blessings was a nurse, while Carrington a consultant pediatric doctor. Carrington is a consultant at the Kenyatta National Hospital as government employee, and at the same time operates his private clinic. Blessings and Carrington were a hardworking couple. They made efforts to purchase properties, which point I want you to underline tenant and tenant. The very first sentence, now that the question has been projected, that they married under the civil marriage. I want you to underline that civil marriage. Their matrimonial home, they have given a block there, Nairobi. That block was registered in their joint, again, in their joint names. Other properties registered jointly were the Nakuru Ngata block, Nakuru municipality, Nairobi Karen, and Mombasa municipality. Mombasa Nyali block is owned by Mary and Carrington as tenants in common. Again, we have that term, tenants in common. Properties acquired and registered by Carrington alone were Nairobi Karen block, Kisumu Milimani block, Kisumu municipality, Muhoroni, some Levy apartments in Lavington, in 2 high-range motor vehicles. Carrington and his doctor colleague, Joel, purchased land and stuff. was jointly owned by Carrington and Joel, and both had medical clinic run from there. Again, you have the jointly owned a term coming up again. In 2000, Carrington was concerned that had too much property and few children, and was advised by his father to marry another wife to bear more children for him. I wish I had that problem, that I have a lot of property and no children. Unknown to Blessings, a traditional wedding was organized in July in 2009. In January 2002, Blessings of the marriage and stamped that out, bearing the name of after Peterson.
And it's
When she
breaking,
consulted
I don't know.
You're not
her,
clear. You're not clear.
And
You're breaking.
you are quite breaking. We are missing your tidbits.
can you hear me now?
I don't know if someone else can read Anne as you adjust your network.
All
Just
right. Yeah, we can. Daniel, you can read the question.
Okay. I'm glad you guys can hear. I want to believe you guys can hear me clearly. Yeah.
Yes.
All right. Bernard. All right. Let me read the question as Anne tries to sort out that problem. So, Blessings married Carrington under civil marriage in 1970. Now, Anne told us to underline that civil marriage in 1970. Their marriage was blessed with two children, James and Mary, born in 1971 and 1973, respectively. Blessings was a nurse, while Carrington, a consultant pediatric doctor. Carrington is a consultant at the Kenyatta National Hospital as government employee and at the same time operates his private clinic. Blessings and Carrington were a hard-working couple. They made efforts to purchase properties which they registered as joint tenants and tenants in common. So we have those two there. You can underline those two. The matrimonial home, Nairobi, Karen Block 12YY, was registered in their joint names. Other properties registered jointly were Nakuru Ngata Block 12/HH, Nakuru Municipality Block 5/XX, Nairobi Karen Block 2DD, and Mombasa Municipality Block 34/106. Mombasa Nyali Block 2/22 is owned by Mary and Carrington as tenants in common. Properties acquired and registered by Carrington alone were Nairobi Karen Block 2/103G, Kisumu Milimani Block 12/104F, Kisumu Municipality Block 10, Moroni, Sam Levy apartments in Lavington, and two high-range motor vehicles. Carrington and his doctor colleague Joel purchased land which they developed and set up business premises, which they named JC Doctors Plaza. JC Doctors Plaza was jointly owned by Carrington and Joel, and both had their medical clinics run from there. In the year 2000, Carrington was concerned that he had too much property and few children, and was advised by his father to marry another wife to bear more children for him. Unknown to Blessings, a traditional wedding was organized and Carrington married Joanne in 2001. In January 2002, Blessing learned about the existence of the marriage when she stumbled upon the birth certificate in her house bearing the name of a child named after her father-in-law, Peterson. When she confronted Carrington, he opened up and told her that he had married Joanne and that Peterson was their firstborn son. The discovery upset Blessing, creating a fertile ground for discontent and frictions in their marriage. Carrington built a palatial home in Kivu, where he moved to stay with Joanne. He would make occasional visits to Blessings. When Joanne got her third child, Duke, in 2004, Blessing could not take it anymore, and she decided to file for divorce in 2005. The marriage was dissolved in 2008. In 2010, Blessings sought for division of the matrimonial property. The parties entered into a mutual agreement to divide the properties between themselves, except those that were owned jointly with other parties or those solely owned by Carrington. In the division of the properties, the following were given to Blessings: Nairobi stroke Karen block that, Nakuru stroke Ngata block that, Nakuru municipality, Nairobi, and one high range motor vehicle. The rest of the properties were given to Carrington except that which they were registered as tenants in common. On 16th January 2011, the court ordered Carrington to execute the relevant conveyance forms to facilitate the transfer of the respective properties. On the 17th January 2011, Carrington was involved in a plane crash in the Mara and died on the spot. At the time of Carrington's death, all John's children, Peterson, Wendy, and Duke, were all underage. Joan had resigned from her job to marry Carrington, and he had told her that he would pay her monthly upkeep to stay home and take care of their young children. Mary is mentally unstable and lived with her mother. James had married and was living in Germany with his wife. The family met after the burial to discuss the distribution of the estate of Carrington. Joan is unhappy and is adamant that her children are young, and if there is anything to be distributed, she must have a greater share of the property owned by her husband. Joan was of the view that her children should have priority over the other children, since she was the official wife of Carrington. She considered Mary as an invalid and undeserving of the inheritance, and that Mary is already provided for by virtue of her ownership of Mombasa / Nyali Block 2 / 22A. That Blessings, having been divorced, is not a wife, and therefore not beneficiary of the estate. As an expert in probate, A, using relevant legal provisions and case law, explain what the fate of JC's Doctors Plaza would be. That's 1. 2, advise Blessings on her rights of inheritance from the estate, if any. C, advise Joan on how to safeguard her rights in the estate, if any, and those of her children. D, proffer legal opinion on the position of Mary as a beneficiary. Those are the questions that we have. Anne, are you back?
All right, thank you. Now, let's begin from A, that using relevant legal provisions and case law, explain what the fate of JC Doctors Plaza would be, and to hear what some 2-3 people think about this, and then we can have a discussion around it. Yeah. I'm not sure whether the problem is on my end. I cannot see. Oh, okay. Nicole?
So my
Let's hear
opinion.
from Nicole.
So my opinion on what would happen to JC Doctors Plaza, since they were joint owners, the remaining share shall devolve to Joel, since they were tenants in common as opposed to joint tenants as opposed to tenants in common.
What is the difference between joint tenancy and tenancy in common?
Nicole,
Okay.
The difference is partially laid out in section 60 and 61 of the Land Registration Act, but essentially the main difference is on the effect of the transmission of the property upon death. So in a joint tenancy, the remaining share of the property shall devolve to the remaining joint tenants automatically, and therefore is not subject to the Law of Succession Act. However, in tenancy in common, since the shares are sort of held as separate and distinct from each other, the share of the deceased tenant in common shall devolve to their estate according to the Law of Succession Act.
Yes, that is very correct. And that is simply it. So you needed to notice that this property was jointly owned and not tenancy in common. And the doctrine of survivorship, say for example, not even for example, let's use the two, J and C, that
C dies, whatever is left will not devolve to any estate that C has, but rather will be survived by the other person who jointly owns this property, and who in this case will be Joel. So JC Doctors Plaza will automatically go to Joel, and Joel will be the new owner of that property. Okay? Yes, Barak.
I'm slightly of
Barak.
different opinion. Can you hear me?
Yes, proceed.
Yeah, I'm of a different opinion, actually the other way around, because I'm seeing that there is a bit of suggestion that this is actually a tenancy in common. Why do I say so? If you look at it, they owned it, but at some point they had clinics. They were operating from there, and there's a suggestion that probably each had his own clinic within that building. So there could have been some level of severance. So you'd find a joint tenancy moving into a tenancy in common because of the aspect of trying to divide the property. And I think also if you look at section 91, there would be, where it is not specified the shares that each tenant holds, then there is a presumption of tenancy in common. That is section 91(2) of the Land Registration Act. So I'm of the view that it could be more of a tenancy in common. I don't know how you find that.
Anyone else that wants to give their input? All right, none. Okay, yes, Evans.
Oh, thank you so much for this chance. I would lean more towards the first speaker. I think the question is very clear. It says jointly owned, yeah. And there's no need to import an unnecessary presumption in this particular instance. So that would be necessary for if then you're not told how the property is owned and you're trying to determine it from the facts. But given that the facts clearly state that the property is jointly owned, I think that there's no need to import the presumptions of tenancy in common.
Evans, anyone else? A final person? Yes, I can see Ayeko.
Yes, I think
Ayeko, go ahead quickly.
you can hear me, right?
Yes.
Okay. So I think unless I'm also leaning towards the first speaker and the third speaker. Slightly, I'm different from Barak's because my understanding is the fact that at the top level, the fact that the ownership at the top level is joint, I wouldn't go into the subset of the ownership. You know, if we bought a book together with Barak, and this book is for us to share, I wouldn't start thinking who is to read chapter 1, who is to read chapter 2, and create another layer of ownership. So I agree that the question speaks of joint ownership as opposed to a tenancy in common. And as such, it devolves in accordance with the doctrine of survivorship. Thank you.
All right. Thank you. Thank you. Now, this
I may
is
have
what I would tell you. Huh? Is
can I add
someone
something?
talking?
Yes,
All
yes.
right,
I just
quickly.
wanted to add that I think the issue of whether a property is jointly owned or it's owned in under tenancy in common, it's at the point of registration, yeah, and not dependent on how it's used by the parties. So if it's registered jointly, then you do not need to assume that it has been that because how it's used portrays some properties or of tenants in common, then you assume the property is owned as under tenancy in common. I think we just go with how it's registered. If it's jointly owned and at the point of registration, then that should be it.
All right. Okay. Thank you. Now, the first thing I really have to caution you about when you're walking in to do the bar exams, do not overthink. Do not, don't go in thinking, now these people have set the hardest of stones for me to go and overturn. No, do not. You do that, you'll start overthinking and you'll find yourself leaving the correct answers and sometimes missing the point and giving the wrong answer. However, this is what I would do, Barak. Just some, now this is not what the degree will teach you, it is just being street smart. Now that you noticed about the tenants in common situation and you see, and the question actually asks you to give legal provisions and case law, if you actually feel your argument about tenancy in common has a legal provision and you have a case law for it, and that question bears 6 marks, please put down both arguments. Discuss that from the registration or from the information that you have been given about these people, this property is jointly owned, and you continue to give the legal provision that you have and the case law that you have. Continue also to say, because the marker will say, okay, this person is not so clueless, they actually know what they are saying. In the event that this property was joint in common, then this and this is what will have applied. You give your legal provision and you give your case law. That way you have covered your mass without an M, making sure that whichever way it goes, the marker will at least give you something in that question. Okay? But the answer in this question, the first answer is that this is jointly owned property, not tenancy in common. So don't overthink it. That is what I'm trying to tell you. And this goes for all papers. Don't overthink what these people are asking you. The answer is just there with you. And trust me, they knew very well when they put it there, the two terms there, that it was jointly owned, and they made sure that they also had a phrase that was going to bring up the tenancy in common so that they see what you're going to do with the information that they have given you. Okay? Are you together up to that point? So argue it out. No answer is wrong, of course, but in KSL you will learn something different. But argue it out. Argue them both out, and if you have the legal provisions and you have the case law that they are asking for, put it down there. If I were you in this first question, I would have given both, that it is jointly owned and also give my argument about the tenancy in common bit. Any question there? I want us to move on to part B. Any question? Excuse me. All right. Part B. Advise Blessings on her rights of inheritance from the estate, if any. Now, who is Blessings in this question? This is the wife that had been married in 1970. Yeah, in 1970, that is, under the civil marriage. So advise her on her rights of inheritance from the estate. Any other person other than Ayeko? Let me hear from someone else before we get Ayeko.
Sorry, Anne, I wanted to ask a question about A. I wasn't unmuting quickly. Would it be good for you to guide us, perhaps also on key legal provisions and the key case laws, if any, so that I know we can refine the books, but could there be one or two legal provisions or case laws that you think must be on top of our mind as we revise that is? Thank you.
maybe I can come in if you're allowed. There is section 91.
Oh, okay. Yes, Daniel, continue.
No, this Barak, section 91 of the Land Registration Act, it gives those scenarios.
I think you're muted. Anne.
Oh, sorry. Been talking to myself here. All right. So this question, the particular one about jointly owned property and tenancy in common is mostly discussed in conveyancing. But I would want to bring your attention to the doctrine of survivorship. Okay, and I really don't want you to confuse this with the doctrine of Comorientes. Trying specific provision about it. But at the moment, what I really have at the top of my head, there's this book by Musioka, the Law of Succession book by Musioka, W. Musioka. I hope you have it. This book will really be of much help to you. And he has discussed something to do with these tenancies and also the doctrine of survivorship in there. That's what I would give you right now. But also look at what conveyancing says about it. Yeah, also the Land Registration Act should have something to say about it. Please check it. Okay, this is not coming up as quick as I want it to. From the W. Musioka book. But as soon as I get it, I could send it to people. All right, so if there's not any other question, we can go to B. Advise Blessings on her rights of inheritance from the estate. And I have refreshed your mind that Blessings is the first wife, basically the wife that was married by Carrington under the civil marriage in 1970. Any attempts about it? Any attempts for part B? Yes, Benedict, Faith.
So personally, I have two arguments about the same question. So under section 29 of the LSA, we are told that they're dependents, meaning of dependents. And as we know, if you're a dependent, you're supposed to inherit. So we can see that there's the wife or wives. Okay, so sorry, let me just read section 29, meaning of dependents. For the purposes of this part, dependent means A, the wife or wives or former wife or wives. So, and the children of the deceased, whether or not maintained by the deceased immediately prior to his death. So this is a former wife. So we reading with this section, she's entitled to inherit from the late former husband. So there's also another position that since they divorced and everyone was given their own share, she might not have so much to take from the deceased estate. So for me, I have two positions that she can inherit under section 29, being a dependent, and she doesn't need to prove whether she was being maintained by the deceased or not. And when we were having a probate class, I remember Miss Anastasia said, once you're divorced and your patrimonial property is divided, you'll need to apply to court, and then there is that discretion of the court that will say whether you're going to get anything from your deceased spouse's estate. Thanks.
All right, there's one other person.
Okay, so
I can't see the name, but I can.
Oh yeah, no, it's me. So my view is my view is sort of informed by the Law of Succession Amendment Act of 2021 that sort of deleted former wife and former wives from the Law of Succession Act. and now it just stands as the spouse of the deceased. So it's sort of informed by that. And since I'm guessing they moved to court fairly recently, I think the amendment would apply. This is also in light of the fact that by the time he passed away, the 2010 constitution had already come into force. So the law would sort of create a distinction of on the basis of gender, which is obviously not allowed within the context of Article 27 of the Constitution. So I would use the Law of Amendment the Law of Succession Amendment Act of 2021, but also anchor it in Article 27 of the Constitution, since it's not clear from the question when they moved to court.
All right. Thank you. Mutunga, did I see your hand up?
I just spoke.
Okay. Okay. Any other person? From my end, I'm really not able to see. It's just the one that pops. So I'm not really able to see the hands that are raised. If there's any other person, you can please go ahead. None other?
Oh, sorry, there's something I'd forgotten to add.
Okay.
Sorry. Yeah. Even though I don't think she's a beneficiary of the estate, I think she would be attached as one of the liabilities of the estate, according to the sort of separation agreement that they had entered into, and it would have to be transferred by his estate upon the relevant letters of administration being issued.
Now, I will back to that question. I think it is the second paragraph. I'm trying to look for that line. Yes. Somewhere past the half of that paragraph where it says in 2010, Blessing sought for division of the matrimonial property. And before that, it says that the marriage was dissolved in 2008. And in 2010, Blessing sought for division of the matrimonial property. Now, for one, we need to identify this woman Blessings as a former spouse, okay? Or a former wife, whichever one you choose to, whichever one you'll understand for the purpose of this revision class. She's a former. And then it continues to say that they mutually agreed, the two of them, between the two of them, they mutually agreed to divide the properties between themselves, except those that were owned jointly with other parties or those solely owned by Carrington. Now, we have already eliminated this property that jointly owned between Carrington and other people. Why? Because we have already learned about the doctrine of survivorship in terms of jointly owned property. So the property in question now is that which was solely owned by Carrington. And I want to take you to section 29. I am hoping I keep confusing between 26 and 29, where it says that people who are considered dependents or people that can actually claim, yes, it's 29, meaning of dependence, that a spouse or former spouse, if not the children of the
You're breaking. You're breaking.
yeah, trees. Can you hear me now?
Better.
Can you hear me now?
No, we are struggling to hear you.
All right. I'm
On and
saying
off.
we have analyzed that. We have analyzed that that second bit, second paragraph of that question, and we have noted that the marriage was already dissolved. So this is a former spouse of Carrington, and Section 29 provides for the meaning of a dependent, and the 29A says that the wife or spouse or wives or former wives or spouse or former wife or wives or former spouse or spouses, whichever one you're choosing for the purpose of this class, and the children of the deceased, whether or not maintained by the deceased immediately prior to his death. So Blessings actually does have a right, and she's entitled to inherit from this man. Why? By virtue of being a former spouse of Carrington, as provided for under Section 29 of the LSA. Are we together up to that point? Are we together up to that point?
No.
Yes, ma'am.
Yes, ma'am.
You lost me?
Yes, we lost you there because could you also please help us understand there is this phrase that they always say that not all dependents are heirs and all heirs are dependents. So someone could be a dependent but not a heir to the estate of the deceased. So should we take Section 29 blanketly as anyone who is a dependent is also a heir?
No, please, no. Not everyone who is a dependent is an heir. No. There's a paper, and I'm not sure whether it was a paper or it was a project work that we did during my time about a man that he had an aunt that, yes, that he was maintaining, and that he was, so the lady actually took M-Pesa messages to court to show, and the receipts for the medicine that the man was buying for her. So she sought to actually receive an inheritance from the estate of the man, not as an heir, but as a dependent of that person. So not all dependents are heirs, please. Let's get that one clear, okay? Do not let Section 29 confuse you, please. Isikudanganye. Not all dependents are heirs. And at the same time, I wish you to notice that although there is something, I don't know whether you have learned at this point about protesting or objecting a will. It is not always that your parents will leave something for you in their wills. It is not always, it is not always that you must inherit from them, no. Right now, you remember how long ago we used to say, oh, if a parent dies, the firstborn son or the firstborn someone is the one that will inherit from them. Things have changed right now. You actually, or your parents, or myself as a parent, when I become one, I have the discretion to choose who I want to bequeath from me. The only thing I will do is, or suppose I am the person that was not provided for in that will, I can only object or protest to that will in court, but I cannot force the hand of a person to provide for me in their will. So that phrase, I will not agree with it completely. Not all dependents are heirs, and sometimes not all heirs will end up being dependents or people that will inherit something from a person's estate. Yes, Hilary.
Okay, thank you for that. I just wanted to ask you about now, what is the effect of this 2021 amendment if you're saying that former wives are entitled to inheritance, yet we've been told that the word spouse has been used now to delete all words that go with the word wife or wives or husband. Just so now, anywhere where there is wife or wives or whatever, we use the word spouse. And now who is a spouse? A spouse is someone you're married to, who's still, you are still married to. It can't be a former wife. So I don't know how we are going to treat that, because from my understanding, I know that former wives they are not entitled to inheritance because they were formerly married to that person, or former husbands or whatever that is. So the effect of 2021 amendment, what's your take on that?
Now, I'm not sure whether I got what you're asking, but isn't a spouse both a man and a woman? A spouse is not one gender, right, Hilary?
Yes, it's not one gender. Yes, that one we agree with you. But my question is, if you're saying that Blessings is entitled to inheritance as a former wife based on section 29, subsection A, then are you trying to say that the 2021 amendment did not have any effect with regards to what the meaning of a wife is? Because a former
Let Hilary finish first, and then whoever is trying to respond can respond. Hilary?
Yeah, I think I'm done. I just wanted to ask that because from what we've been taught recently based on section in this amendment and anything to do with wife or husband, it has to be as for someone you're married to, not someone you are divorced with to, or a former wife or husband. It has to be someone you are still married to, and that is the meaning of spouse with regards to the amendment, and it takes us back to the Marriage Act. So I disagree that Blessings will be entitled to inheritance based on the fact that based on section 29A as it stands right now.
Okay, can I have a bit? Okay, I'm the one who.
Yes, proceed.
Yeah, I spoke about section 29 earlier, so I wanted to say something about it. The word wife or husband is what has been replaced with spouse. Does not really mean that the former wife or former husband has completely been removed, unless I read that amendment wrong. So if I understand that correctly, it should mean the spouse or spouses or former spouses or former or former spouse or former spouses. So I understand that it is just the word wife that was replaced with the word spouse. So that is why section 29 might give Blessing a right to inherit as a dependent according to section 29. So unless I understood that amendment in the wrong way, maybe you can educate me, please. Thanks.
I have it here. I can just read it for everyone to get it. Section 3 of the Law Succession Act is amended by inserting the following definition in proper alphabetical sequence. Spouse means a husband or a wife or wives recognized under the Marriage Act. So for the Law of Succession Act to call you a spouse, you have to be a wife or a husband, or a husband, wife, or wives as recognized under the Marriage Act. So when we go back to Marriage Act, what does that mean again? For you to be called to be recognized as being married, then what are the type of marriage? It can't mean that you can't be divorced at that point. You have to be married. So unless you want us to open the Marriage Act, it's just my understanding that now there's nothing like former wives from this insertion of the definition of what a spouse is.
I have a question for you. So once you are divorced, you're a former what? You're a former wife or a former husband, yes? So once you're divorced, now you become a former spouse. Yes? And that is what section 29 is trying to explain to us as the wife or wife or former wife or wife. So if you're divorced, you're already former. And then this is why section 29 recognizes it. Unless you tell me that former wife was repealed, was just removed at all, and it is not there in the amendment act.
I'm not sure. Was it Benedict that was talking, or is Benedict another person?
Benedict Faith is my name.
Yes. All right. And I had seen three more. Can get one.
If I may come in.
Yes, proceed, please.
Okay, I think for me, I want to look at the mischief that Kaluma, actually this must be the Kaluma amendment. I'm looking at the mischief that Kaluma wanted to cure, you know. And we have seen recently, you see, these laws, they serve the society, and the society has some kind of behaviors. If we go back to our jurisprudence classes, you realize how the law was defined, dependent on what society, this jury, are they called the juries or the jurisprudence were coming from. And you would see our society today is made up of mpango wa kando, sponsors, sponsees. So what Kaluma wanted to cure is this kind of interpretation. And I don't think after severance after formal severance of a union in what we call divorce, a marriage still exists. Yeah. And that said, I think the definition of the word spouse should be someone who was living with the other partner at the time of death, or who was in a functional relationship at the point of death. If I look back, of course, LSA as is now, as we read now, Section 29 speaks to former wives. But when was that law, when was that law passed? So when we see this new amendment, you actually can read the kind of mischief Kaluma wanted to cure. And in my understanding, Blessing may not have some space in is it Joel or Carrington's life? So I don't think Blessing deserves to get any property since she's not a spouse, which means current partner to Carrington. Thank you.
And if you may allow me to come in, this is Kamau. I think what Bernard is talking about is mostly on what was on the Kaluma bill, which had over 20 amendments that it wanted to introduce to LSA. But what came out from the amendment as an act was only one amendment, and that was on the definition of a spouse, that it must be a man or a woman recognized under the Marriage Act. And I would say that amendment actually brought more confusion than the cure it was supposed to have brought if the bill had been passed as Kaluma had proposed. When I looked at this 2023 paper, and especially the best performed paper, the person had actually quoted Section 29A, so that Blessing can come in as a former wife. And the examiner actually cancelled that answer. So I don't know, because there seem to be some two schools of thoughts. There are some people who have taken those amendments for 2021 to the effect that Section 29A has been repealed, and former wives no longer qualify as dependents. And that is the school that was taken even by the examiner. But in terms of amendment, I differ, because the amendment only amended the term spouse and did not affect Section 29A. But for the examiner, that is the person that he had taken, if you are to look at the best performed for 2023. Thank you, Anne.
If I may also chip in, once there is a divorce, then what follows is division of matrimonial property. So I'm just trying to look for a case that supports what I think, because I know once you are divorced, then you are severed from the deceased. And once you divide the property, then that is the end. I would agree with the person who marked the paper that a former wife who went through divorce and decided that they would divide the matrimonial property, and if that was done, then they cannot come back and inherit from the estate of the deceased. So I'm looking for a case. When I get it, I will share with you on what the courts have also said about the status of divorced wives.
Anne, if I may. Anne.
All right.
Okay. So, guys, I think maybe there's something that we have to understand here, even as we move forward. Yes, we have the amendment, but I think it's important that we understand what the amendment is amending. Yeah. If you read the amendment, I think it was read to us by someone, and I think it's clear that the amendment is amending the meaning of the word wife. Yeah. And it's talking about section 3, which is on interpretation and what this and that means. Yeah. Now, I want to agree with all of us that we've always had an issue with definition of the word wife, because there are people who believe that even if there was a monogamous marriage at first, even if you marry again in a polygamous type of marriage, then this person is still considered as a wife. I think you guys know that particular section. Now, the amendment amends section 3. It does not talk about section 29. I mean, someone just read it for us. I don't know. I don't know if maybe we'd like this person to read again, but I think it's very clear. It talks about section 3. Now, section 3, remember, which talks about the meaning of the word wife. Okay. Section 3 does not talk about dependence. I think we have to make that separation. Now, if you look at section 29, section 29 talks about the word wife, the wife. So when you're talking about the wife in section 29, we have to look at the amendment. Who is the wife according to the amendment? According to the amendment, a wife is a spouse as defined in the Marriage Act. But if you look at section 29, we have to look at the use of the word or. They're not using the word and or anything else. They've said or. So the first scenario, wife or wives, okay? That's the first scenario. Second scenario, former wife or wives. So these issues are separate. When you're talking about a wife, then you have to look at what the amendment is saying. How is the amendment defining a wife? You can't go past what the amendment is saying. But does the amendment also talk about former wives and say that former wives means a wife as per the Marriage Act? No. Wife is what we have now. Former is someone you married before, you are married before, and now you are not married at all. So I think we would be wrong to try to use section 3 to define section 29. And the word used there is disjunctive or. So we are not putting these two together. We're not saying wife and former wife. And the amendment is also saying what we are amending is the meaning of the word wife, the meaning of wife, not the meaning of wife and former wife. Those two are different. So yes, we have an amendment, but the amendment amends the meaning of the word wife. It does not amend the meaning of the word dependent to only mean a wife. 29 says the first scenario is wife, and you'll use the amendment. Fine. But also we're talking about a former wife or wives. And they've used or. That's a disjunctive. So you cannot read the two together. But for you to define a wife, you have to use the amendment. Former wife, you can't use the amendment because the amendment does not define former wife. It defines a wife. So I think it would be proper for us to use section 29 and include former wives. And I think that would be my contribution.
Oh, okay, I got the case, if I may. I got a case. It's succession course number 1152 of 2017 in re-estate of KDB deceased 2020 EKLR. So the court has the court was saying that if you look at paragraph 30 of that case, the court is saying that a former wife can claim a share out of the estate pursuant to Section 7 of the Matrimonial Property Act, especially where the property in question was acquired during the subsistence of marriage. So if you look at the question is telling us that the lady called Blessing had requested for division of property. And I think that should also guide us. If at all there was already a division of property under the Matrimonial Property Act, then she doesn't have a recourse now to come back and claim after that had been done. But if the property had not been divided, then she can claim pursuant to Section 7 of Matrimonial Property Act. Thank you.
Anne, I'm sorry for the lack of order. I know you're the one you're the one leading us. And I think also for the guys coming after Anne, let's maybe raise up our hands that Anne can, tell us who is talking next. But I think Pius, I think maybe you're saying we are saying the same thing. Just I don't know why you are coming up with this argument. I think from the case that you've read, it's quite clear that we can consider a former wife as a dependent. And I think that's what we're talking about here today. Then again, I mean, every time we're talking about a former wife, I don't think we are alienating those wives who are former wives by dint of having a divorce. And I also think that every time we have a divorce, property is always shared. So are we saying that since the property has been shared, then now you're not a former wife, now you're something else? What are these people? What are we going to call them if not former wives? Okay, so every time you have a divorce, yes, property will be shared, but you are still a former wife. There's no other name that we are going to call you that, and I don't know what that name is. So these guys are still, that's the name that is their name, they're former wives. And I think from the case that you've read, a former wife has the right to be considered as a dependent. So I don't know, Pius. I think it's quite clear. And I think you're making an argument, but I don't think there's no case law for it. Yeah.
I think I've got something to add. Pole kwa kuingilia katikati.
Yeah, maybe you can just raise up your hand. Anne, maybe you can.
Yes, I've raised my hand.
Okay, you then we can have Anne. You said you wanted to add something.
Yes, I wanted to add something on top of it. Am I allowed to proceed?
Yeah, go ahead, sir.
Okay, thank you. Now, this is what I've done. I've actually opened the amended bill, the amendment bill plus the bill itself. So the bill at 29, it talks about the meaning of dependent, which says for the purposes of this part, dependent means A, the wife or wives or former wives or wives and the children of deceased, whether or not maintained by the deceased immediately prior to death. That is how it is. The amendment at section 3 says, section 29 of the Principal Act is amended by A, deleting paragraph A and substituting, therefore, the following new paragraph. The spouse or spouses and the children of the deceased, whether or not maintained by the deceased prior to the deceased's death. So this means that the Principal Acts at section A, section 29A where it talks about the wife or wives or former wives has been deleted. And then I went further in my research. I got a newsletter from Kaplan and Stratton. This newsletter talks about law of succession. I've already sent to the WhatsApp group the Amendment Act, and I'm also going to share the this newsletter. I'm also going to share it at the WhatsApp group so that tuone sote. So it says this.
Sir, can I interject, please?
Okay, please.
Yes. Yes. So first, let's agree what you've read is a bill, yes, not an act.
No. Yeah, that's why I'm now going to what Stratton and Kaplan has said.
Okay, all right.
Yes. So the Stratton and Stratton newsletter reads, on 17th November 2021, the President has entered into law the Law of Succession Amendment Act 2021. The Act will become operational 14 days after publication as an Act of Parliament in the Kenya Gazette. It is currently waiting its publication to result in amending certain provisions of the current Law of Succession Act, which governs the administration of a deceased estate. The key changes are as follows. It talks about intermeddling. That is not part of argument today. Then it comes to speak about spouse. And this is what they say. Spouse, the Act now defines and limits a spouse to a husband or a wife and excludes former wives. I'm sending it to the WhatsApp group so that tuichambue zaidi na kwa kina. Thank you. That's what I wanted to present for now. Thank you very much, Mr. Oduor, for the opportunity.
Anne, I'm trying to raise my hand.
Yes, I've seen you and I wanted to call you. Please come through.
So guys, yeah, thank you so much for that addition. I think that was quite important. Now, the reason why I emphasized on what you read, and I told you what you've read is a bill. And I think someone also said it here. Yes, and we remember, I think this bill was introduced during our time at KSL, and I mean, we were very happy that finally they're going to define dependence again. But please, I'd also urge you to look at the act that was assented to. And I think someone read it here. Someone just read that act. Yes, that is how the bill looked like. The bill even talked about dependence. The bill talked about deleting the word former wife. But what was gazetted only defined spouse. It didn't talk about 29. What is gazetted is what is law. So yes, we had a bill. The bill talked about dependent. The bill deleted wife. But what was gazetted was definition of the word spouse and not definition of dependent and deletion of former wives. And that's why we are trying to make that difference. We have to separate those two. The bill talked about dependence, but the act that we have only defines the word spouse. And what has force in this country is the act, not the bill. And I think, I don't know if now maybe we can move to the next question. I think maybe it's
Yes, we can. Yes, we can. Yes, we can. I was waiting for someone to notice that there's a difference between a bill and an act, and it's good to check what was in the bill and what was actually taken up into the act. Thank you for that, Daniel. Guys, don't be confused. I tell you, verily, verily, I assure you that even me, during my time, we had that argument about the spouse and the former thing and all of it. We had it all. Please don't get confused. And I actually know where the confusion is coming from. We have two lecturers that I will not mention by name, for which one is saying this and the other one is saying that. Now, please note, in as much as these lecturers are the teachers and they know it all, make sure you check what is in the act. The marker of the paper you will do come November will not be marking based on what a lecturer said in class in KSL. They will be marking based on what is in the act. Be keen to see that. So guys, please be keen to see that. Please don't get confused. All right, I want us to quickly go to, I think that was part B that we were doing, but nonetheless, it's a productive discussion. Did I lose? Okay, I have it. Patsy says, advise Joan on how to safeguard her rights in the estate, if any, and those of her children. Now, Joan being this lady that was married secretly, okay, before when Carrington realized that he was having a lot of property and few children, and so he married her through a traditional wedding. Anyone that has something? I just want 2 people, and then we move on. Any 2 suggestions or any 2 contributions on this one? Guys, quickly. Yes, Nicole.
So I think the key thing in this question is about the date on which they were married. So wait, sorry, let me just bring up my question. So it states that they were married in before like 2014, which is obviously, yeah, they were married by 2002. And obviously this was prior to the Marriage Act 2014. So the Marriage Act of 2014 obviously doesn't apply. As such, what we should deal with is CAP 150 and the definition of wife or wives of spouse in the Law of Succession Act according to Section 35. And as such, notwithstanding the provisions of other written law, she should be a wife. So in relying on this, you should use Section 35 of the Act. In regard to her children would obviously be allowed to inherit. This is in line with Article 53 of the Constitution and Section 32 of the Law of Succession Act. However, if somebody were to have any difficulty in proving the marriage, they would also be able to prove cohabitation. And this is based on the Hortensia Wanjiku Yahweh case versus a public trustee, which basically laid out 3 conditions. They must have been living together for a long time, which is obviously proven here. It tends to suggest the presumption of marriage if they've been living together if they have children, and they must have been carrying on as man and wife in the eyes of their neighbors. So I think for the purposes of this question, she would be a wife, and obviously her children would be allowed to inherit pursuant to Section 3.2 and 3.5 of the Act.
Thank you, Nicole. That's good. That's good. I'd want you to realize that the question asks, advise her on how to safeguard her rights. And you did well, Nicole. Any other suggestion? Any other contribution to that? Daniel, I cannot see whether there's any other raised hand, so I will assume there's none. All right, so none.
Go ahead.
Yeah. Sorry?
Go ahead.
All right. So thank you, Nicole, for your contribution. That's it. That's it. You really need to see the ears. Be keen to see the ears when this traditional wedding took place, and then ask yourself when the relevant act came into place. And then now that is how she's going to prove. That is how she's going to either substantiate herself as a wife or a person that should actually receive from this estate. Can you hear me?
Yeah, loud and
Yes, we
clear.
can.
But now you're muted. Anne, are you there? Or
I think she left the meeting.
okay, guys. I want to believe that your answer is okay, and I think it proves the reason as to why she needs to safeguard her rights. But I think the reason as to why she needs to be considered, and I think you've talked about 3.5 and 53.1E and 3.2. I don't know, just an addition, and maybe I'm overthinking here, and I think maybe we can we can help each other. We can't see Jules. I think we can't see the paper again. They're asking us to explain how she can safeguard her rights. How can she? Yes, she has. You see, we've established that she has rights. Yeah, and I think that's what 3.5, 3.2, 53.1E does. But how can she safeguard that particular right? I don't know if I'm overthinking it. Anyone else thinking the way I'm thinking? Yes, I have. It's the same way I'd say I have the right to property. I bought it. I own it. But how can I safeguard that particular right? If I had to safeguard it, like what can I do to safeguard it? Anyone? Because I think we've established that, and if I'm overthinking, then I think we won't go towards that direction. Okay. All right. Then we can have it. We can have it like that. But maybe just have it in your mind. Maybe we can get back to it. Yes, Benedict Faith.
I had a question. So I've heard about the discussion that we should check about when someone was married, and then if it's a monogamous marriage, and then if it's a polygamous marriage when it happened. But when we were having a discussion in class, we were told, I think by Madam Mungare and also by Madam Anastasia, that even if someone was married monogamous and then they end up marrying polygamous, the wife that was married under polygamy will always have a right to, it will always be a wife according to the Law of Succession Act, but not according to the Marriage Act. So I think I might stand guided about the same, because I really want to understand. So what if someone is married polygamous after a monogamous marriage, and it's now post 2014 when the Marriage Act was enacted?
Yeah, so I think we've had two diverse arguments in relation to what you're asking. But in relation to this particular question, if you look at it, I think we'd have to go back to section 3.5, which is an non-obstante clause. Now, the reason as why that clause starts with a notwithstanding is because it understands that there's something else, and maybe this is a different situation. This is an exception. It is creating an exception. Okay. And I think that's why, the person who answered the question was very right to go back to tell us the year, to tell us everything and why this is going to apply. I think that was very important and very careful. Now, because we have 3.5 and it starts with the word notwithstanding, it means that yes, maybe the Marriage Act, maybe another act have defined this to mean something else. Okay, that is fine. And maybe the Marriage Act says something that we are not going to say after writing this word notwithstanding. But notwithstanding the Marriage Act and any other acts which maybe have said something else, for purposes of succession, we are saying that this wife who has been married after a monogamous marriage is still going to be a wife anyway for the purposes of succession. So where we have a notwithstanding clause, it has to be taken that maybe the situation is different somewhere else, especially in 3.5. What it is saying is maybe the situation is different somewhere else, but notwithstanding that situation, notwithstanding that provision that provides otherwise, we are coming in to say that for purposes of succession, that's why we are creating this. This person who is married after monogamous marriage is going to be considered a wife, and they will not be thrown out of court whenever they come to court to ask for this particular person's property, the person who is dead. And again, I think it's very important for us to look at the history of this and what the parliamentarians at that particular time were trying to achieve. Now, before this time, we had people who are coming to, before they come to the city, or maybe at the city, they decide to have a monogamous marriage with someone. And I mean, it was lovely and beautiful and blissful to have a marriage in church and have everyone there coming in to be joyful and tell you, oh, congratulations. Then after a while, you move somewhere else. Maybe you move from the rural area to town, and you meet another wife, another person, and you decide to actually marry this other person. Now, because the Marriage Act, or the act at that particular time, I think it had a different name, was very strict, and it was very clear that after you've had a monogamous marriage, you can't have any other marriage because you have a subsisting marriage. And so many women suffered because of this. And I think we have so many cases in relation to this because of that problem, because of the fact that we had so many women who are being sent away because we are saying that there's a subsisting marriage. We are sorry you did not know, but you see, this person was already married. The parliamentarians decided to sit down and come up with something in the Law of Succession Act to cater for these women who ought to have been left without anything because of what the law said. Again, the law is for us. So when the lecturer said that, yes, the Marriage Act might have said this, but for purposes of succession, this is what we are saying. It was to cater for that particular problem, to achieve that particular goal. So for the law of succession, yes, we are considering them as a wife. But for the Marriage Act and the act we had before the Marriage Act, they were not considered as wives. I don't know if that clarifies your question, and I don't know if the history helps and the rationale for that particular provision helps to understand.
Yeah, thanks.
Thank you. Okay, now I see we have a few hands. Enoch?
Yeah, I wanted to talk about the point you raised earlier on our answer for question C. And I think there is more to that statement on how to safeguard our rights, because according to how we've currently answered it, it's just similar to how we answered question B. And I think for that question C, we'll have to actually answer on the steps Joan can take to ensure that she actually ends up on the list of those inheriting, and also her children. So for me, I would say on part of safeguarding, maybe we'll talk about how she can maybe consult a lawyer, find out the process of administration, ensure she's on the list of dependents, something along those lines.
Okay, that is, yeah, that's a good trial and a good first step. I think that would earn you some marks. Yes, that would be the first step to safeguard. Yes, thank you so much. Thank you so much, and thank you for thinking like that. Yeah, I think that is it's very critical. You have a right, but how do you safeguard it? Thank you so much for that, and thank you for helping us to think like that. Yes, Nekesa? Sharon?
Yeah, so mine is with regards to the spouse, the amended, one of the amendments that passed, that is the wording spouse. So what is the effect with that with regards to section 29.2, which says that the husband must prove maintenance? Because in 29.1 we have the wife, so the wife has been done away with, and we have right now the spouse. So what is the effect of 29.2? Is it still there, Ama?
Okay, we can answer that. Do we have any other questions apart from that? Okay, we don't have. Anyone would like to answer her? She's saying yes, she's fine with 29. Yes, Nicole, yes, I think. Nicole, go ahead.
Okay, I have a different opinion than you in regard to section 29. While I agree that it may not have been explicitly repealed, I do think that it's worth noting that part 5 is where the provisions of unintestacy begin. And obviously, at that point, all of the relevant sections are substituted for the word spouse. So I feel like that's the interpretation I would take. And this is also grounded in the fact that we can't have former wife or wives, because I feel like it would be inconsistent with the Constitution, because it creates discrimination on the basis of gender, contrary to Article 27 of the Constitution, and also following the case of Ripples International versus Attorney General. It doesn't deal with Section 29 or spouse or spouses, but it dealt with, I think, Section 35, where it said father if dead or mother if dead, and it stated that the creating a hierarchy on the basis of gender between the parent and between the two parents was discriminatory and contrary to the Constitution. So I think that's my reasoning on it. I don't know whether you'll agree with that. But for sections, C, one thing that we may or may not have mentioned, because I broke off from the meeting for a bit, is that we haven't mentioned that her children are minor children. So she would have to be one of the people who petitions the court or one of the administrators and hold it in trust for her children until they attain the age of majority.
Okay, all right. Thank you for that. Thank you for that answer. And I think, yeah, we really have to think about this in so many different directions. And again, it's a debate that we keep having. Hopefully one day we find a solution or how to go. And I think for me, what I'd say is so long as you're able to, defend whatever you're saying, your argument, I think it would fly. Yeah. Now, there's someone who has asked me about 29C, which says that where the deceased was a woman, her husband, if he was being maintained by her. And I think you've talked about that. The person who just answered said, I keep forgetting your name. Yeah. And I think, yeah, that is discriminatory. If you look at Article 27 of the Constitution, that would be discriminatory. I mean, why? How comes when it comes to a husband, then they have to prove, but when it comes to a wife, they don't have to prove? Now, you could use that to say that it doesn't apply. Well, this case has not gone before court, and the court has not declared this particular section unconstitutional, or I don't know if there's a case that has declared this particular section unconstitutional. But I want to believe personally that it is unconstitutional because it doesn't agree with Article 27 of the Constitution of Kenya. Now, again, you said since the amendment defines spouse, and it says spouse includes wife and a husband as defined in the Marriage Act and everything. So yeah, I think when it talks about her husband is a spouse. I mean, and I think there's no problem with that. The Marriage Act also talks about that. But I think where the issue comes in is the fact that when the spouse is, well, the Act says that a spouse is both a husband and a wife. But now when we come to 29C, it says when this particular spouse is a husband, then this husband has to have to prove, and that is discriminatory. Then I think we'd have a problem there. So yes, spouse is defined to include a husband and a wife, and I have no problem with that. I think what we should be talking about, or what we should be looking at, is the fact that when the spouse is a husband, then they have to prove that they were maintained by this particular person. That could be a problem. Now, whether you can use Part A to have this person as a spouse and delete Part C, I do not know if that would be proper. But I think personally, I'd leave Part C as is, but then use Article 27 of the Constitution to say or to argue that it is unconstitutional, and so it wouldn't work at all in any way whatsoever. And maybe just use the definition of the word spouse to even, to just emphasize or to give more ground to what I've actually said by using Article 27. But yeah, I think that's also a very, very good question. That would be my answer. I don't think if I'd say anything else. The person who asked the question, would that at least work for you?
Yes, it will. Thank you.
All right, yeah. Anne, are you back? Or okay, I see she's not back. Okay, so I think we'd go to D. Unless we have a question, please just carry up your hand and you can ask your question before we move forward. Okay, so a legal opinion on the position of Mary as a beneficiary. Anyone? What is her position as a beneficiary? Mary. So I think you'll just tell us who Mary is, then what we mean by the term beneficiary, then maybe give us a legal opinion. Now that we know who Mary is and the meaning of the word beneficiary, what would be her position in this particular matter? Would she get anything? Would she go home without anything? What would actually happen? Anyone? She's mentally unstable, that I can say. And she lives with her mother. Anyone? What would be her position? Please do not shy away. I hope I haven't been harsh to anyone. Just let us know what you think. We can have a discussion on this. Anyone? Yes, Nicole.
Okay, sorry, I was afraid of like sort of monopolizing the discussion, but it's my opinion that she is a beneficiary. And for that, I would use obviously Article 53 of the Constitution to sort of state that by like as a result of her mental illness, it doesn't disqualify her from sort of inheriting, since all children are entitled to inherit. And I think there are similar provisions in the 2022 Children's Act. Then obviously there's the issue of the property that was registered in both her and her dad's name, but in that instance she was registered as a tenant in common and not a joint tenant. Therefore, his share shall devolve according to the laws of intestacy under the Law of Succession Act. But when we sort of deal with the distribution of this estate, okay, my interpretation is that we should use Section 35 of the Law of Succession Act. So where the intestate has left one spouse and child or children. So we should look at the situation of her sort of mental state and what that means in terms of the future needs of her as a child of the deceased. And we should also look at the fact that she received a gift to sort of try and think about the extent of the share that she would receive. So yes.
All right, thank you. Very, very clear. Anyone who maybe would like to add something that maybe Nicole hasn't talked about, especially in relation to, I'm not saying that because of her mental issue, because she has special needs, then she can't get the property. But anything else, any addition to what she has said, which is very correct. Yeah. Any addition? Anything else? Yes, Bernard.
Maybe for me, it's just to ask if my response will be in form of a legal opinion, and in that case, in form of a letter to maybe Mary or to someone who is a representative of Mary, with with all the principles or the guidelines issued in writing a legal opinion. Like I would go with something like the FIRAC format. Will I be out of scope?
No, it would be proper. You'll be giving a legal opinion, and you're trying to do your best to ensure that your legal opinion is, well elucidated. So I don't think there would be a problem with that. Just ensure that you don't write too much facts. Don't ensure that you don't write the whole story again. Whatever you are writing should only relate to Mary. Okay, yeah, I want to agree with what Nicola said. It's very clear. Again, she's worried about monopolizing this meeting. Guys, we are 88. Please, one thing that we have always encouraged, man, let me tell you, we are all brilliant people, man. All of us here, the fact that we've reached here, we are all brilliant. Never, ever allow anything to shut you down. Nothing should shut you down. Just say whatever you think. Just give us your opinion. And again, this is how we even learn to come into this corporate world and be able to open up and say what we think. And of course, we know about our profession. If you can't speak, we won't know. If you can't speak, we won't know what you have. And so I'd just like to encourage all of us, please, just say whatever you think. Say, in fact, sometimes when you say whatever you think and you're wrong and you're corrected, you tend to remember more than if you didn't speak at all. Okay, and we're all brilliant. The 88 of us, all of us. So again, please let's try our best to ensure that Nicole is not worried again about monopolizing this particular meeting. So please just Just say something, even if it's a 2-word sentence. Just say what you think. Let's just contribute. Just say something, man. Don't keep quiet, man. You're very brilliant, and we'd like to hear what you have. We'd like to have your contribution. All right. So yes, I want to agree with you, Nicolia. That's proper. And I want to again, Bernard. Yeah, FIRA can help. It makes things easier and better. It makes your legal opinion easily understandable. But Nicole, I was just wondering. Yes, the fact that she's mentally unstable doesn't mean that she's not a child. And yes, I agree that we use 35 because we have a spouse and children, and that's how this would devolve. Again, Nicole, if you realize, we also have these are the people coming in. Apart from Blessings, we have another lady who is coming in, and we talked about 35. So I don't know if 35 would actually apply here, but yes, I also agree with the fact that there's tenancy in common, and so the property would devolve through the process, the normal process. But again, because of her mental unstableness, do you think that maybe it would be proper for someone to hold this property for her? Because I don't think she has the capacity to hold. Yes, she's a beneficiary, but maybe her mom would hold it on her behalf. What do you think about that? That maybe you can just have that as your conclusion?
Yes, I do, but I know that she'd have to sort of go to court to have herself appointed as a guardian. Rely on sections of the Mental Health Act. I don't remember what sections, but I think it's section 11 or 12, but I'm not too sure about that. Yes, yeah. So it would be held in trust by Blessings, since she wouldn't have the capacity to sort of take care of the property.
Yeah, she doesn't have the capacity to hold or own in particular property. Thank you. So I think you can just add that as your last point as we move. Yeah, as we move to the next one. Any questions in relation to that? Yes, Elvis?
Not really a question. Okay, no, there's a question, but I also wanted to offer to read question two. One was, the question is rather, during the briefing with CLE, I don't know if he was an examiner, but he was in charge of exams. He mentioned that whenever we use FIRAC, we waste the examiner's time. And so his emphasis was mostly on diving straight to the analysis, because in your analysis, you will state the law. You will arrive at a conclusion. You think about that.
All right. So I think you're trying to make the examiner's work easy. Yeah, there's no problem really. What I think is, if you have time, you can use FIRAC. Not to waste examiner's time. Go ahead and analysis and everything else. Again, if FIRAC is too long, you can use IRAC. So issues, as you move forward, rules, application, conclusion. I don't know if that would take a very long time, but again, I want to also agree with you. There's no time. You don't want to waste the examiner's time. You want to move quickly. You want to get all the points. You don't want to bore anyone. Yeah, we dive straight into it. I think it will depend on, as you do that paper, what do you think really matters? And how do you want to do it? But again, I think FIRAC could be a bit too long, Bernard, but yes, you have the freedom to do it. Maybe we can do IRAC or use whatever has been suggested by Elvis. I think that would work. It's a matter of decision. Julian? Then we can have Elvis read for us the question. Yes, Julian?
Sorry to take you back. I think I missed it. What did you people say about section 35 of LSA? Would it be prudent that we use section 40 instead?
Yeah. Nicole, what do you think? Now that we have quite a number of families and 35 is applying.
I don't agree with Blessing being a spouse.
Oh, okay. You're coming from that. Okay.
Oh, yeah.
Is it Blessing or Joan? Oh, because she's a former wife, you don't agree with her being a spouse?
Yes.
Oh, okay. So, Julian, I think.
And John? And John?
My opinion was that Joanne is a spouse, by virtue of the previous legal regime.
Okay. All right. So,
And-
Julian, I think. Okay, go ahead. Go ahead. Sorry, I don't want to cut you off.
Oh, thank you. I'm looking at section 35 and it relates to just a minute. It relates to an intestate has left one surviving spouse and child or children. And because you agree, oh, okay. Okay, I see what you're saying. So because you don't agree, Blessing being a wife, being a dependent, Joan is the only wife remaining. I think okay. I get what Nicole is saying. Okay.
Yeah. Yeah, so that's where she's coming from. So for someone who believes that both Blessing and Joan are wives, then I think 40 would be proper. But for her, since she believes that Blessing is not a wife, then she has decided to go with 35. Again, guys, I agree with 40, but again, if you disagree with Blessing being a wife, then I think it would be proper to use 35. Again, man, for me, what I usually say is you just make that choice and we see how it goes. I could think I'm very right, but maybe you are. Maybe there's something I'm missing. But I think if you're going with whatever I think is proper, I think you would use 40. But according to what Nicole agrees with, you'd have to use 35. And I think I respect both opinions. Okay, Elvis, you wanted to read for us the second question?
Yes.
Okay, go ahead, sir.
Okay. Could kindly. Okay, thank you. Mr. Bisai, excuse me. Mr. Bisai had one wife, Alice, who bore him 4 children. He also had a son, Abednego, whom he got with a lady he had a secret relationship with. Mr. Bisai had in place a will wherein he bequeathed everything to Alice and her 4 children. Back in his mind, he knew he would later amend his will to include his son, Abednego. However, this did not happen as he died abruptly following a tragic road accident. After his burial, Alice, armed with the will, sought the services of a lawyer. One of the witnesses to the will, who was a close friend of Mr. Bisai, informed Abednego about the will and even gave him a copy. Abednego, who was a second-year university student, was distraught that he was left out of his father's will and decided to take legal action. He subsequently visited the Pro Bono Lawyers Association, where you are employed as the legal counsel. His matter has been allocated to you for your action. Part A, explain the type of application you would institute on his behalf.
Then B.
And B, with the help of case law and relevant statutory provisions, discuss 4 circumstances that the court would consider when ruling on applications of this nature.
All right. Thank you so much for that, Elvis. Yes, Anne, Gisheru, Anne, I see your hand was up. Do you like to start us off?
Yes, I am not so sure, but I'd love to give it a shot. I'd say for A, I'd go with a caveat, which is usually lodged by filing form 28. And the caveat would, number 1, prevent the will from being admitted to probate. And although it's not an issue of appointing a personal representative, the caveat also has such an effect. So the caveat basically is usually lodged before a suit or in the middle of a suit of admitting a will to probate or appointing a personal representative. So the type of application for question A, that's what I'd go with.
Okay, you said a caveat can only be
I've said the reason I'd go with a caveat is so as to stop the will, the one that Mr. Abednego has not been included in, from being admitted to probate, and I'd do that by filing or filling Form 28.
Yeah. Okay. Any other person? Yes, the other raised hand. I can't see your name, but just go ahead. Apart from Anne, there's someone else whose hand is raised. Please go ahead. Okay, I want to believe there's no one else. Now, Anne, I think you explained the type of application and you also named the application. Yes, Evans? Which application would you make? Evans, yes. Any other person whose hand is raised? I can see so many hands. Ama Evans, you want to go? Evans? All right. Evans, I think you can mute. Any other person? We have another answer, yeah? If your hand is raised, yeah.
Can you hear me?
Yeah, I can hear you.
Yeah, what I was thinking of making I don't know whether it's, but what came a reasonable provision based on one to section 26 and 29 of the law. So I was thinking that we would make summons for reasonable provisions for him as a dependent of the deceased.
Okay, so you reasonable provision 26. Noted.
Hello.
Yes, go ahead.
Yes, I was having difficulty at mute. I would agree with reasonable provision also under section 26 and Rule 45 of P&A.
Okay. Someone else? So we have a caveat and we have reasonable provision. If your hand is raised, just unmute. I can't see the names. I don't know why.
Yes, Edward, my hand
Okay, hello, can you hear me?
Yeah, after you will have Pius. Go ahead.
Okay, he said you can say anything.
Yeah, go ahead. You are brilliant. You can say
My
anything.
opinion,
Yeah.
I would I would petition the court for the grant of something to do with pendentility to challenge the validity of the will for having left out this dependent. Yes, for having not provided for the dependent. That is it.
Okay. Okay.
Edward, can I take?
Yeah. We'll look at what it
Okay.
but yeah, thanks for that trial.
Okay, so I agree with the first speaker who talked on caveats, because in this instance, there is no application in court yet. You know, the Abednego has information that was left out of the will, and I don't know, he has a copy of something of that sort. So there is the matter has not yet gone to court. So what is he supposed to do at such an instance? Because you also have to let the facts lead us. In this instance, he has information that he hasn't been included in the will. But and that's where now caveats come in, as the first speaker mentioned, because if you read Rule 15 of the probate and administration rules, I hope I can read it. It says 15.1, any person who wishes to ensure that he shall receive notice of any application, either for the making or the confirmation of a grant of representation to the estate of a particular deceased person, may enter a caveat in the registry. even if you just stop at that, it will help us, because now as Abednego seeks to put in the application, for caveat, so that anytime an application for a petition for grant of representation comes in, he will be notified, because now when he's notified, then he can come in and challenge the will on the ground that he's been left out as a child to the deceased. So I think it's the right application to make in this instance, because the matter has not yet come to court.
Thank you. Thank you so much.
Thank you so much. Yeah.
Okay. We have another raise.
And another thing, I've just forgotten. Those who are talking about Section 26 on reasonable provision. Remember, it's on reasonable provision. You only go under Section 26 when a provision has already been made and you are dissatisfied with that provision, either under testacy or intestacy. You can never invoke Section 26 at any point without provisions already having been made and you are dissatisfied with that, either under will or intestate. So I think you can rule that one out respectfully.
Okay.
I think with respect, I disagree with the speaker. I think, if you read question B, question A and B are tied together. Yeah? So for me, question A expects you to answer reasonable provision, and then B, you explain the circumstances under which reasonable provision would be granted. So if you go with the caveat, then you might as well abandon B because you'd be stuck. Huh? So you have to look at the whole question in a complete manner.
Interesting. Thank you. And we read those two together. Evans. Last two. You then. Come on. Yeah.
I've just spoken before, right now.
Oh, sorry. Thanks. Is there any other raised hand? One last person. Okay, we have none. So explain the type of application you'd institute on his behalf. B, with the help of a case law and relevant set of provision, discuss 4 circumstances that, please move up a bit, Julian. Sorry. Yeah, with the help of a case law and relevant set of provision, discuss 4 circumstances that the court would consider when ruling on applications of this nature. Okay, so I think one thing that we really have to ask ourselves is, has provision been made? I think the question has told us clearly that there's a will, and a copy of this will has been given to Abednego. And I think where we are talking about probate, provision is made in accordance to the will. Yes, so I think it would be proper to say provision has been made, just that the formal process has not started. But I think provision has been made through the will. If it was intestacy, then maybe it would be different, that provision has not been made. Yes, and so I tend to go with 26. And if the question is provision, I tend to believe provision has been made because it has been made in accordance to our will. And I think the facts are telling us that a copy of this will has been given to this particular person by a witness who witnessed the same will. So Abednego actually knows how everything is going to devolve, and Abednego actually knows that he doesn't have reasonable provision because he has the will anyway. A copy of the will has been given to him. I don't know what you think. Would that change your answer? Sorry, I've forgotten your name. Would that change your answer? The person who spoke before Evans. Would that change your answer in any way whatsoever? Now that we know the provision anyway, because we have a copy of the will. If you look at the facts, I think it shows that he has a copy of the will, and even when he's coming to see you, he's coming with a will.
I think based on part B, and for purposes of being safe in such a situation, then I'll go with the section 26 and your mambo na will. But if you look at it ideally, I don't know what's the best, because as a child and you are not provided for in such an instance, what will you do? Yeah, so I think most of it inakwanga invalidation of a will, because as a parent you are, it's one of the grounds for invalidating a will actually, if you look at case law, if you have not provided for some of your children. So I don't know, but going with part B and for purposes of exam, I think we'll just go with section 26.
Yeah.
Provision evil too.
But I'd also like to reiterate that if you look at section 5 of the Law of Succession Act, actually every person who is of sound mind and not a minor may dispose of all or any of his or her free property by will. And they have the right to decide how they want to do that. I think in this question someone has written pauper versus pauper and everything else, but I think if I can actually decide to leave my child out of the will, yes, it is a ground to challenge the will, but I don't think it would automatically invalidate the will, especially where probably I had reasons as to why I left this person out of that particular will. And I think you can look at the case maybe of there's a case that we looked at. When I get it, I'll tell you about it. There's this person who decided to leave his child out of the will, and it flew just like that. There was no problem at all, because I think the kid was a delinquent or something, and so because of that reason, he decided to leave the child out of the will, and the will still survived. But yes, it is a ground to challenge that particular. It's a ground to challenge it. But Section 5 says I'm free to give it and will it as I want. But anyway, yes, you also make a very good point. So if you go with B, if we say we're going with 26, so which grounds? What would we be looking at? Evans, maybe you can tell us the 4 things, the 4 circumstances that the court would consider. Guys, the 4 circumstances that the court would consider. Anyone? The 4 circumstances.
Okay, I think I'll just read them from the Act, Section 29, Section 28. In considering whether any order should be made under this part, and if so, what order, the court shall have regard to A, the nature and amount of the deceased property, B, any past, present, or future capital or income from any source of the defendant, that's the word used, the existing and future means and needs of the dependent, whether the deceased has made any advancement or other gift to the dependent during his lifetime, the conduct of the dependent in relation to the deceased, the situation and circumstances of the deceased's other dependents and the beneficiaries under any will. Then the last one, the general circumstances of the case, including, so far as be ascertained, the testator's reasons for not making provisions for the dependent.
Thank you. So these are the circumstances that would be taken into account, and if all these boxes are ticked and there is no problem, it would fly even if someone was left. But if one of these, touches on this will and there's a big problem, then again we'd really have to, go through another direction. Now, if you look at it, it says the conduct of the dependent in relation to the deceased. And I'd like us to look at the case of Barry versus Batlin when you have time. Barry versus Batlin. This is a case where the dad decided to leave the child out of the will because he believed that the child was a delinquent. And even if he left for the child 50 million, the child would actually do nothing substantial with it. And I think he gave all the money to a charity, or I don't know he gave it to who, but he didn't give anything to a child. And that will flew as is. Anyone with a question, anyone who would like to disagree, anyone with a different opinion, it's an open session. Please, this is your time. You can just raise your hand and go ahead. Tell us what you think. We have no one at all. Okay. Anyone would like to read for us question 3? Guys, it's an open forum. Very open, quite open. Please.
William, Daniel.
Yeah.
On the Canvas side, now again on answering this question, what if some other person would, if you can one effectively and adequately argue with regards to invalidation of that will, based on the ground that he's a child and is entitled to the father's property, just on that ground. And then, I don't know, if we put section 26 aside, because there's a will involved here. It's like you're forgetting issues to do with the will alone. Because now we know there's that part where as an heir, as a rightful heir of the deceased, one is morally obligated to provide for their dependents, especially children and wife. So in this instance, can't one argue in that regard? I don't know.
Yeah, and again, if you Article 53.1 that I think been talking about again and again. It also talks about, the fact that a child has to be provided for and it must be equal from the mother and the dad. Yeah, you can also use that. But again, I'd also like us to realize and to know that right is not absolute. It can be challenged. It's not an absolute right. But yes, I think you can use that ground to actually, convince these guys to actually provide for this child. And I think you can also use, I think it's C, the existing and future means and needs of this child. Yeah, you can also use that. And even the Children's Act, the best, the best interest of the child. Yeah, that's okay. That's okay.
Daniel,
Please,
I'm not sure you can see my hand.
Yeah, that's okay.
Okay. All right, go ahead. Go ahead, the person whose hand is up.
Okay. I think courts have been hesitant to invalidate a will.
In which circumstances? In all circumstances?
Someone has removed me. I don't know who does it. Okay, fine. But what I wanted to point out is that courts have become hesitant to invalidate a will in a way that interferes with the testamentary freedom in cases where a child has been left out. So in such cases, actually, the approach we've taken is the preferred, that where you've been left out even as a child of the deceased, not child in the sense of a minor, but child as in biological, notwithstanding, it's no longer, courts are becoming hesitant to accept it. If you look at John Wagura Ikiki and 7 others against Lee Mutoga case, you'd find that the courts are saying that where you've been left out of a will, then the best approach is to seek for reasonable provision. So court will not ordinarily invalidate a will by the mere fact that a son or a daughter has been left out.
Thank you. And I think it would be proper to go towards that direction. I think that's what we're doing. Thank you so much for that addition. Yeah. And again, the way we keep saying, I mean, yeah, the freedom is also there. Yeah. But I think thank you for also telling us that the courts have been a bit hesitant. If you take that route, you could be having problems here and there. So the easiest and the best route is to use 26 and you'll get reasonable provision. But one thing that I've always wondered, the person who just spoke, let's say we get reasonable provision. So they say, oh, you know, you're a child, your school fees need to be paid and this and this. And excuse me, the testator had bequeathed everything they owned to these particular people who are in the will. What happens? Are we going to tell you, Brian, we're going to take a half of your property and give to Abednego? You will take a quarter and give. What happens really? Do we invalidate the will? Again, I'm just asking you, do we invalidate the will and start over in intestacy? Or do we keep the will, but then modify it so that we're able to provide for this particular person? Yeah, what happens?
I think there's a conflation between two issues. A child as, for purposes of the biological child, and a child as a minor. So if you're a child as a minor, then probably that will bring invalidation much closer, because we'll now be acting on the best interest of the child. And in that particular case, maybe there will be reason to consider invalidation. If you look at Tau Katungi case, I think at the first instance, there was a bit of a child who was left out. Okay, but later on, he was included, the child was included, although it took long for him to get his fair share of the property. But that is because there was life interest in the property. But the fact is that he was included by virtue of being a child, and a biological child for that matter, a child both by age and a child as a biological progeny of this deceased person. But then if you compare that case with the Lee Muthoga case, you'd find that in the Lee Muthoga case now, we are dealing with adult children. And these adult children, again, you look at how they had behaved with the deceased person. And the court is saying, no, you are children of the deceased, that's acceptable. Your biological children, that's right. But suggesting that at your age and based on how you related with the deceased, it's not a ground to invalidate. So I think, yes, it will be a ground to invalidate if we're talking about minors. But if we are talking about adults, then probably it will not lead to invalidation. Or you'll be included. I don't think invalidation, because you see, the other thing to consider is that there is a rebuttable presumption of the validity of a will. Omnia esse riteata, I think that is what they normally say. So there's the presumption of validity of a will. So to invalidate a will also takes a bit, quite a bit. So it's possible that the person who has been left out, the will can be invalidated, or if there's a way that it can be included, the child can be included and the redistribution taken. That's my perspective.
All right. And thank you also for separating the two, where we have a child who is below 18 and we have a child who is an adult. Anne, you're back. You can, we just finished question 2. Maybe we can go to question 3, or if there are any questions, maybe you can deal with the same. Anne? Okay, I don't think she's back yet. Can we move to the next question? Yes, you can just scroll down, Julie. Anyone willing to read for us the next question?
I will read it.
Okay.
So question 3. Question 3 reads, Julie wrote a will in 2006, leaving all her estate to her siblings, Paris and Jenny, should she precede them in death. Due to Julie's health condition, Paris was entrusted to take care of her. Her condition required someone to be around her to assist with her movement and daily care. Julie's demands often left Paris exhausted, and so she will forget to attend to some of her chores in the house. This infuriated Julie and made her to revisit the will to remove Paris from it. In one of the days, Julie grabbed her will from her bedside drawer with the intention to revoke it. Patrick and Cooley, her nephews, had visited her that day and were in her bedroom when she intimated to them that she wanted to revoke her will and would need their assistance. She handed the will to them who burnt it within her compound. 3 days later, Julie died and an issue arose as to the will she had written. Using relevant legal provisions and case law, discuss the validity of Julie's actions. If it's okay, I'd also want to give it a shot.
Go ahead, go ahead.
So from my understanding of the question, it's an issue of revocation of a will. And from my understanding, a will can be revoked in a couple of ways. There's implied revocation expressed by marriage and also a revocation by distraction. And from my understanding, the actions of Julie handing over the will to her nephews who burnt it, it's revocation by distraction, and revocation by distraction occurs through burning, tearing, or destroying the will with the intention of revoking it. And so for revocation by distraction to hold water, there has to be actual distraction and the intention itself to revoke the will. So from this question, Julie had the intention to revoke the will, which was expressed to her nephews, and then there was actual distraction by the will being burnt by the nephews. And I think for a legal provision or a case law, I'd go with Cheese versus Lovejoy, where the will was, in this case, the testator wanted to revoke the will by cancelling out some clauses and some signatures, and he also went ahead and wrote that all these have been destroyed, all these have been revoked, sorry. But in that case, the will was admitted to probate because as much as there was intention to revoke the will, it wasn't actually destroyed. That's it.
All right, and I think we'd use section 17. Let me just read them very quickly. A will may be revoked or altered by the maker of it at any time when he or she is competent to dispose of his free property by will. So the first thing we're going to look at capacity. Is that soundness of mind? Are they able to dispose of the property at that particular time? Looking at our case, this person was not mad. They only had an issue with movement. Yes, I don't think they had unsound mind. They had a sound mind. Then if you look at section 18, no will or codicil or any part thereof shall be revoked otherwise than by another will or codicil. Declaring an intention. So again, we must have intention to revoke it or by the burning, which it's our case here, tearing or otherwise destroying of the will with the intention of revoking it by the testator or by some other person at his or her direction. I think Julian's answer is quite clear. Do we have anyone dissenting? Any dissenting opinions? Any?
It's Gisheru, not Julian.
Okay. Oh, okay. Sorry. Sorry, sorry, Anne. Any dissenting opinions? None. You can read for us B. Anne.
All right. By a will, Diana bequeathed all her estate to Paul, her only surviving relative, and Rose, her best neighbor. She had a copy of the will in the bedside drawer and one kept by her attorney, Caleb. Diana and Rose had issues that constrained their friendship over the years. Diana decided to make some changes to the will and deleted Rose's name from the will. She then took out the will and cancelled Rose's name using red pen, signaling her dislike for her. Diana appended her signature and date on the deleted sections of the will. Diana died and her will was found in her bedroom with the deletions. Paul is happy as he now remains as the sole heir of Diana. Paul has gone to inform Caleb of the changes Diana made to the will and insists that he be given all the properties by Diana to the exclusion of Rose. He also informs Rose that Diana had removed her as the beneficiary of the will. Rose has sought help from you. Advise her on legal rights, if any.
Okay. Someone else? And I know you're ready to get the 10 marks. Yes, Yatich, Stephanie? Stephanie, Yatich?
Yes, yes,
Go
can you
ahead.
hear me?
Yep, loud and clear.
I had a question before we proceed to the second part of question 3. In part A, have you said that the will was revoked?
Yes, that's what we've agreed on. And do you have a different opinion?
Yes, I do.
Okay, go ahead.
Because if you read section, I think 17, which talks about 18, which talks about revocation, it can be through another will or codicil, or by destruction, or by a subsequent marriage. But then if you look at Musyoka's book on the part where he talks about revocation of a will through destruction, he talks about it being, there has to be intention, the actual act of destroying the will, and if it is done by, it can be done by either the testator or someone else under the directions of the testator, but then the other person who's destroying the will has to do it in the presence of the testator. But if you look at the question you've been given, Julie was, let's say, bedridden. She couldn't get out of her room. And the question, the examiners, they consciously wrote that the nephews, they went and destroyed the will, not, but they said she handed the will to them who burnt it within her compound. So clearly they were not in the presence of Julie, who's the testator in this question. As such, that will was not revoked through destruction. It was not a valid destruction of the will.
Can I, because can I rebut that?
Go ahead.
Yeah, it does not say presence, it only says, because if you read section 18 of LSA, it says, save as provided by section 19, no will or codicil or any part thereof shall be revoked otherwise than by another will or codicil declaring an intention to revoke it, or by the burning, tearing, or otherwise destroying of the will with the intention of revoking it by the testator or by some other person at his direction. You know, it's just, yeah, that section 18, subsection 1.
I don't disagree with you that extent, but then I'm saying if you look at Musyoka's book, he has construed that section to mean that that destruction must be done by the testator or someone else in the presence and direction of the testator. The nephews were not in the presence of Julie when they destroyed that will, and the examiners of that question, they have written they went to the compound, and we've been told in the question that Julie was bedridden, meaning that she did not see the nephews destroy that will.
Did she give the directions? No? Just asking.
Yes.
Did she give directions that she? I'm just asking.
She
By the way.
did
You don't have to say yes.
directions. Oh, yes, she did.
So we agree
And
that
that's
she gave
what
directions.
and that's what the law
She
says.
was not present. Your issue is that she was not present, and Musyoka's book says that she has to be present. Yeah.
Can I add something to
Okay.
that discussion, please?
Yeah, go ahead.
So Musyoka's interpretation of that section isn't completely unfounded, but it's based on a case in Re Dad's Goods. So it was similar. A testator was bedridden and wished to revoke a codicil. So her executor and a neighbor went out of her presence into the kitchen and burnt the codicil. So it was held that there was no actual destruction. If destruction is done by some other person, it must be done in the presence of the testator and by his direction. So that's where Musyoka's interpretation of it needing to be in the presence of the testator arises.
All right, so it's a difference. We have to look at it differently, yeah.
Yes, because even, okay, I think I can add to, apart from redads, you also have Gill versus Gill. And in both cases are in Musyoka's book, and he talks about the destruction being done by the testator, or someone in the presence and direction of the testator. And even if you look at, if you go to the CLE website and you look at the past papers, they usually post the highest code. And the marker, when you look at the highest code paper, he actually, you have, if you look at question number 3, the answer, when you look at the high scored paper, the will was not revoked because it was not made in the presence of Julie.
Okay. The only issue I'm having is that the Act talks about direction. It doesn't talk about presence, and I think we get our authority from the Act. And I think maybe in that scenario, because it was a different case, this guy is actually, from what the previous speaker said, even directions were not given. These guys just got out of her presence and decided to go and burn it. But in this scenario, actually, she intimated that she wanted it revoked. So it's not like we had intention. I think if we are able to prove direction, then I think it would be proper.
Come in.
Yeah.
The permission. I think the person who was projecting the act could, that same person project the act actually in section 18, the position that is being advanced by Stephanie, which is supported by Musyoka, still stands. Therefore, I find Stephanie's position being the proper position in this question. Again, if you look at that question, I think the examiner, by stating that what was affecting the conduct of the person who had been included in the will was because of the demands of taking care of the lady. She got exhausted, and which is ordinary. I mean, it's a normal thing. It's biological to get exhausted when you are doing some things. And that has been stated there. But now the lady could not appreciate that. And again, the fact that that will was destroyed, as Stephanie has pointed it out of the, I mean, without the presence, the physical presence, or, I mean, the intention can only be reinforced by that aspect, which I think, if you look at section 18, subsection 1, that aspect is, in my view, is the proper position as it has been advanced by Stephanie. If you read that section 1, actually, the last part of that sentence or subsection, it is talking of by the testators, but I mean the intention of revoking it by the testator, which has been alluded there, but that will has been destroyed out. Okay, it is disjunctive in this sense, it has been written, but then the background of the exhaustion part of it, I think it's not a luxury for it to be provided there. I think it was to remove, to make that thinking, to dent the thinking of the testator when it comes to disinheriting the lady. Yeah. Am I being heard, or I'm speaking to myself?
No, we heard you clearly, don't worry.
Okay, thank you.
Okay, guys. So, well, I had I don't know what to tell you guys, man, because in this scenario, I want to believe that we had capacity, we had intention. I think what we are looking at is direction, because I don't know if from the facts, I don't know if we can say that she told them to go and burn it, or they just took it and burnt it. But again, we're told that she intimated that she wanted it revoked. So she intimated that she wanted it revoked, but would that mean that she told them to actually go and burn it to revoke it? The only thing that I have an issue with is this fact of the it has to be done in her presence. I don't know. The act doesn't talk about it really. I know we've talked about it. The act, it's not there. It's nowhere in the act. And so I want to believe that maybe cases must be treated differently, but I also want to believe that maybe that is what the examiners were looking for in this particular scenario. But for me, if I was able to prove that there was direction, I don't think I'd look at whether this person was actually present, because that is not provided for in the act. But yeah, Stephanie, I don't want to disagree with your point. I think it makes sense. Being present would really be important. But I think what the act talks about is direction. But Stephanie, I think you have something to say. And again, thank you so much for bringing that up. I think it's a different perspective that is very important. I also have to say and declare that I don't think we'll finish revising this paper today. Go ahead, Stephanie. So you can just take your time. Stephanie, go ahead. You want something to say? If you're unmuted, we can't hear you. Is there anyone else whose hand is up and they want to say something? Was raised the hand and they want to say something?
Sorry, I just wanted to bring up the issue of presence, but I don't have anything else to add.
All right, and I think
I have one thing to add.
Yeah.
Yeah, sometimes, especially when it comes to the highest scored or the best performed papers, I think sometimes you should look at them with caution, because when you are revising, we have all the resources with us when revising, because we're also there's a question someone was best performed, but if you look at it, if you look at the answer that person, the student gave, it wasn't as conclusive as the question required, But now when we're going through, that's when we realize that the person ought to have given more with regards to that question. It was a criminal paper, it was a criminal paper, and it was at that point that we realize at times it's just not about the answer. At times it's about how you explain, how you bring out your argument and such, because I don't think they have a certain way of which people should bring out their answers, but it's just how you explain this stuff. Because if we put all the facts that we've been given here at sides and the law, just to say that that's the right answer that Stephanie has given, then I think we might be defeating the objective of this whole revision thing. At times, yeah, it can be a best performed paper, but it doesn't mean that was the best thinking person.
All right. Thanks. Guys, let's end it like this, okay? I'm going to do my own research and look at this aspect of presence, the fact that this person has to be there. And I think you can also do your own research and look at that aspect, the fifth aspect that I think we talked about capacity, intention, and actual distraction. But now I think we're talking about presence. So let's say that we are going to do our research in the next meeting when we meet, or if we're able to meet within the week, or we can also chat through this in the main group. Let's compare notes and see what we have. Okay. So I think that would help, Stephanie, so that we move to B. Stephanie, that's okay?
Yes.
Maybe
it's okay.
Daniel, just before you, Daniel.
Yeah.
If I seek your intelligence a little bit, just along that school of thought that is being advanced by Stephanie, if you look at Section 17 of the Act, I think the emphasis that is being laid there is the same state of mind okay, being, I mean, like that one of making the will itself when it comes to revocation of the will. Now, if you look at the scenario that we are being given here, and you remember when the execution of the will is being done by actually the witnessing and all that, you see the question of the presence of the testator, especially when attestation is being done or the witnessing. The presence of the testator is there. I don't, okay, if you apply that same kind of thinking, I think even when it comes to distraction, it won't be bad to infer that that distraction must be done in the presence of the testator or under his or her direction. Okay, if we have to apply Section 17 of the Act the way it is. So still, I find it that school of thought, which has been ably advanced by Stephanie, will still stand. And as you have advised that we go and research about it, as you also research, I thought it was good probably to bring your attention to that as well. Though I know you are sized of it already. Thanks.
It's okay. It is fine, guys. We can research on it, but I think even as we go to research, it's clear that we have capacity, we have intention, we have actual distraction, direction was given. The only thing we're looking at is the fact that, you know, as you have alluded, we need this person to be present when this is happening. Please, we will compare notes in our next discussion and see if it is actually true that it is a must. But I think, again, we must agree that in Section 18 of the LSA, it doesn't talk about presence. It's not there. It talks about direction. It doesn't talk about presence. But again, you've talked about a few cases here, and then you talked about Musyoka's book, which I really, really, respect. So we'll compare notes. We'll compare notes. There's no problem. But thank you so much for that also, for just, having us have that discussion. Now, probate is one paper that you can discuss forever and not finish. And that's okay. We always have different answers. We always have different opinions, but that is the beauty in it. Our minds are open. We have to, we get to look at things differently. Now we know about cases that talk about the fact that this person has to be present and all that. So I think that's very important. Let's look at B. I don't know if you've read it. If you've read it, anyone with answers so that we finish in the next 18 minutes. B. Julian, could you read for us B? I know you're the one projecting, but you're the only name I see. Go ahead.
Yes, I can read for you, for few people. The question.
Yeah.
Daniel, can you hear me? The question, okay. B, by a will, Diana bequeaths all her estate to Paul, her only surviving relative, and Rose, her best neighbor. She had a copy of the will in the bedside drawer and one kept by her attorney, Caleb. Diana and Rose had issues that constrained their friendship over the years. Diana decided to make some changes to the will and deleted Rose's name from the will. She then took out the will and cancelled Rose's name using red pen, signaling her dislike for her. Diana appended her signature and date on the deleted sections of the will. Diana died and her will was found in her bedroom with the deletions. Paul is happy as he now remains the sole heir of Diana. Paul has gone to inform Caleb of the changes Diana made to the will and insists that he be given all the properties left by Diana to the exclusion of Rose. He also informs Rose that Diana had removed her as a beneficiary under the will. Rose has sought help from you. Advise her on her legal rights, if any. 5 months.
All right, anyone? Was this will amended? Anyone? Yes, Nico.
So my opinion is that the will was not amended, and this is a result of Section 20 of the LSA. that requires for any amendment to the will to be signed and attested as required of a written will. So since it wasn't properly executed and attested, since there weren't two witnesses who saw the testator sign, it isn't valid.
All right. Now I'm asking for dissenting opinions. Please don't keep quiet if you have one. Raise your hand and speak. Anyone with a dissenting opinion? Anyone with a dissenting opinion? Anyone? If your hand is raised and I can't see it, go ahead.
Mine is not a dissenting opinion, just to say that the provision under Section 18 provides for the ways that a will can be revoked, and they just provide that it is by another will or codicil, so not by cancellation of the will as was done here, but then by providing for either a new will or a codicil, then that would be considered as having revoked the earlier one. But by what she did and the provisions of the Act, then we cannot consider that full revocation or revocation as would have been required by the Act.
All right. Okay. Now I've asked for dissenting opinions. I think we have none. Now I'm also asking this question. What about the fact that she had a copy and the original will was with Caleb? Would that have any legal effect to this particular matter? Let's say her copy was, attested it correctly, everything was done correctly, but then before she died, before her death, she didn't talk to Caleb and give Caleb this new will. So we have two wills, the first one and this second one. What would that mean? Anyone? We're assuming that this second alteration or amendment was done properly as per Section 11. Everything was done properly. But now, before her death, we have this one which has been amended or altered. And we also have the other one which Caleb has. Which one would stand, Anne?
So in response to that question, I'd want to be guided by Rejones, the case of Rejones where the testator had destroyed, or rather had cancelled out the name of a particular, I think it was the niece or the sister, but then after cancelling out the name, the instructions, sorry, she died before the instructions were effected by her advocate. And so oh, sorry. I'm sorry. Also, yeah, I was saying she died before the instructions were effected by the advocate, but it was still held that the will was cancelled out because she had the intention to revoke and it was absolute.
Yeah. Anyone with a dissenting opinion? Anyone? Anyone with a dissenting opinion? So what Anne is saying is that it doesn't matter whether the advocate was there when this alteration was being done. So long as it was done properly, then this copy of the will that is altered, but attested to correctly, would be the right will and not the one that the advocate has. Anyone with a dissenting opinion, and why? Okay. We don't have. Let's go to question 4. I'd like to agree with you, Anne. Question 4. Again, question 4. Julie, maybe if you could scroll up a bit. It can be our last question. Oh, all these questions. Okay. Gabriela, we've moved. You want to read it for us? Someone wants to read?
I can read.
Go ahead.
Gabriela was diagnosed with COVID. Okay. Gabriela was diagnosed with COVID-19. There's an echo.
Are you using
Was
two
diagnosed with
devices?
COVID. Sorry?
Go ahead. Now there's no echo.
Okay, let me read. Gabriela was diagnosed with COVID-19 coronavirus in February 2020. She was immediately rushed to hospital and put on oxygen immediately. After a few days, she was sent to quarantine facility in the outskirts of the city. Had the media reports on the disease, she believed her days were numbered. She called her daughter Madonna and her son Maradona and informed them that in case of anything, all her assets should be divided equally between the two of them. She further told them that her fiancé Ronaldo would administer the estate since he was trustworthy and he knew everything about her properties and finances. She also told them that she intended to give him the commercial plot in Membley as a gift. She felt that by gifting him the said plot, he would not neglect her children. She then called Ronaldo and told him that she had given him the said Membley commercial plot as a gift and that he would administer her estate and ensure that her children got equal shares of all her property and assets. She then told him to organize for a Zoom meeting between her two children, himself and herself, so that she could proclaim everything in the presence of everyone. 2 days later, they had a Zoom meeting and Gabriela emotionally proclaimed, "I am not certain I will survive this disease, and these are my wishes in the event I pass on. All my possessions, including cash in banks, shares, plots, and real estate investments shall be shared equally between my two children, Madonna and Maradona. Ronaldo shall be the administrator of my estate, and I hereby appoint him the executor of my wishes. I have given my commercial plot at Membley to Ronaldo as a gift. I have also given him the Land Rover Defender 110 as a gift since he helped me buy it." She asked her daughter, Madonna, who had a good handwriting, to put everything in writing and to have each of them append their signatures. This was done and dated 14th February 2020. Gabriela stayed at the quarantine facility and was discharged after 2 months. The doctors told her she was at liberty to go home and continue with daily life as she no longer had the virus. Gabriela was finally reunited with her children and fiancé in December 2020, while on Christmas vacation. Realizing how fragile life was, Gabriela and Ronaldo decided to formalize their relationship. They set in motion plans for a traditional marriage ceremony. They set the date of the wedding as 22nd August 2021. Before then, Ronaldo extended family was to visit the Gabriela's family for purposes of fulfilling the traditional rites of dowry. In consultation with her family, the visit to her home was set for 15th April 2021. On the 13th April 2021, while on the way to her rural home for preparation for a tragic accident, and she died on the spot. She left behind her son, who was still a minor of 17 years old, and her daughter, who was 20 years old and had just been admitted to Ivy League University to study psychology. After the funeral, Gabriela's elderly father was keen on petitioning for grant of letters of administration to enable him administer the estate. Ronaldo was of the view that he was the deceased husband since they lived and cohabited together and had already planned a wedding. The children were of the view that their mother's wishes in the document dated 14th February 2021 should be upheld as a valid will. A, with the help of case law and statutory provisions, give a legal opinion on the validity of the gifts that Gabriela gave Ronaldo on 14th February 2020. B, assume that Ronaldo had gone ahead to petition for letters of administration stating that he was a deceased husband. Madonna and Maradona approach you for advice after seeing it in the special gazette notice. Maradona has turned 18 years. They are both worried he may lock them out of their mother's estate since he did not include the names in the petition. Explain the proceedings you would need to file and the grounds thereof so as to protect their interest. C. Explain whether Ronaldo is a husband of the deceased for purposes of succession.
Very clear. Who would like to answer the first question? The help of case law and statutory provisions, give a legal opinion on the validity of the gifts that Gabriela gave Ronaldo on 14 February 2020. Anyone? If your hand is raised, go ahead.
Oh, okay. So the first question is slightly deceptive. And that's because the way it's phrased, it would give you the impression that it's supposed to be a donatio mortis causa, however, it isn't. So it's not a donatio mortis causa for two reasons. One, because Gabriela sort of survived the ailment for which she was contemplating death. And two, because it's not property that's capable of forming the subject matter of donatio mortis causa, since it's immovable property and the act requires for movable property. And I think that's in section 31 of the act. So I feel like that's pretty clear. However, since it's not a donatio mortis causa and it's not a gift inter vivos, since there wasn't an effect transferred, I don't think the gift would pass to Ronaldo.
Any dissenting opinions? Now, Nicole, do you have any case laws? Or
okay, the only case law that I can recall right now is the case of Kane versus Moon, that also lays out the requirements of part of the requirements of section 31. So that's the only one that I can recall right now.
all right. Thank you for that. Kane versus Moon. Anyone with a different opinion? Please do not hold back. Anyone with a different opinion? Anyone else with an opinion? Any opinion whatsoever?
Odor, I am wondering whether we can bring in the provisions of Section 9 and maybe state that because she had stated she had gifted this orally, that now we can discuss the issue of oral wills and say that whatever was gifted through this oral will cannot stand because of the time frame for the validity of the oral will had ran out, seeing that the gift was made in 2020 and then she passed away way later, so it can again not fall for consideration as an oral will.
I would just like to agree with that. And this is also informed by the case of estate of Kevin John Ombajo, which was trying to sort of deal with the question of audiovisual wills. So the deceased had made a will through a video recording, and the court was trying to tackle to where it would fall within the context of the Law of Succession Act. However, since he had made the recording 7 months before he actually passed, it couldn't be an oral will. And the court also found that it couldn't be a written will since it didn't meet the requirements of being signed by the testator. And that also applies in this case, since she asked her daughter Madonna to write it and to have each of them, meaning Madonna and Maradona, sign it. So it wasn't signed by the deceased.
Okay, guys, so we've looked at oral will. It doesn't meet the qualification for an oral will. We've looked at written will. It doesn't meet the qualification for a written will. We've looked at donatio mortis causa. It doesn't meet the elements of that. We've looked at inter vivos. It doesn't meet the qualifications of that. So I think that answers our question, yeah? And we can move to the next question, unless anyone has a dissenting opinion. Yes, Lim?
Yes, thanks, Daniel. Mine is on the question of the approach, considering that they are asking so specific to the question of the gifts to Ronaldo. Do we really need to consider the question of oral will in this case, or we just kind of center ourselves in answering the question of the gifts to, given to Ronaldo?
In my opinion, I have no problem if you start with gifts and you start with Mortis Cosa, go to inter vivos, quickly go into oral will and provide or conclude that even if we're talking about a written will, it is not a written will because it didn't meet the qualifications. I have no problem with that. But again, you can also restrict yourself and just talk about the gifts alone.
All right, thanks.
But just to have a very solid answer, I don't think there would be a problem if you just delve into those other ones, just to ensure those 4 marks are in the bag no matter what. B, I'm sure we have no dissenting opinion. Again, if you don't have time, talk about, you can, underline can, talk about the gifts and leave out everything else. Assume that Ronaldo has gone ahead to petition for letters of registration, stating that he was the deceased husband. Madonna and Maradona approach you for advice after seeing it in the special gazette notice. Maradona has turned 18 years. They are both worried he may lock them out of their mother's estate since he did not include their names in the petition. Explain the proceedings you need to file and the grounds thereof so as to protect their interest. Anyone? 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 This should be quick. Anyone? Anyone? So we already have a petition, names have been included. Now explain the proceedings that you would need to file and the grounds thereof so as to protect their interest. Anyone, guys, anyone? Anyone apart from Nicole? Yes, Stephanie?
I think you'd start by saying that, first of all, Ronaldo is not a husband to the deceased. And when you look at the Law of Succession Act, Section 66, I think it talks about persons who can petition for a grant. And it talks about a surviving spouse, public trustee, children of the deceased. And in this scenario, Ronaldo was not married to, what's her name? Gabriela. As such, he cannot be considered a husband to Gabriela and does not have capacity to petition the court for any letters. As such, the only people who have capacity here is Maradona, who has turned 18. Yes, as such, Maradona and the other sibling, they can object to Ronaldo petitioning the court for letters of administration.
All right. Anyone else? Very well noted, Stephanie. Anyone else? A different answer, a different perspective. Nicole, you agree with the fact that he's not a husband?
Yes, I do. But I don't know whether that should be tackled at this point, since it's a question, like it's its own question under question C.
Yeah.
But okay, with this, I'm not too familiar with the topic, but I think they should also file an objection. And I know one of the reasons that people can file an objection or object to the grant is sort of where the petitioner hasn't been truthful about all the beneficiaries of the estate.
All right, so explain the proceedings you would need to file and the grounds. So we've said it's an objection. Which grounds are we going with? We have so many grounds. Which ones are we going with here? Anyone? And guys, I'd also like us to explain the difference between objection proceedings and protests. Yes, go ahead, sir.
Yes, so another ground is consent. So for you to petition for grant of administration, then the beneficiaries must also consent to your petitioning. So we are told Ronaldo and Maradona have now turned 18, and I think there was also no consent. So that is another ground.
Yes. Okay. They had not turned 18, so who was to give the consent?
They have turned one of them was 18 years.
They're saying Maradona has turned 18 years.
But
I don't know if that means that he was 18 years even before the petition was filed, but maybe, yes. Consent.
There was the other one who was in the Ivy, I think in the Ivy League University, who was 20.
Oh, all right. Yeah. Anyways, yeah. Okay. Any other ground, guys? Any other ground? We have. Which other ground would you have for objection? Yes, go ahead, Nicole.
Sorry, I think one of the things that could be stated is that the petitioner misled the court or was deceitful towards the court, since he didn't clearly list all of the beneficiaries. So it was obtained improperly.
All right. So, guys, what are we objecting to? Are we anyone who can complain, who can explain what is our intention in this application? Anyone who can explain that so that we make it easy and clear to deal with? Nicole, go ahead.
Okay, I can
what
just.
do we want? What is our intention? What do we want here?
I can just try. So I'm guessing this is the first Gazette notice within the period of, I think, 30 days before you issued a further grant. Like, sorry. So this is the first, after he's just petitioned, where the court gives a period of 30 days for it to be published in the Kenya Gazette. And then once, if there are no objections within that period, it's supposed to be published for a period of 6 months, after which the final letters of administration shall be granted to the petitioners. So at this point, you're trying to avoid the petitioner being granted the letters of administration even prior to the 6 months, since it doesn't say it's been, what's it called? Oh, it's been confirmed, yeah.
Sorry. So you said, what is the intention? Sorry, just come up again. What is the intention?
To prevent letters of administration being issued to Ronaldo to the exemption of Madonna and Maradona.
Okay. And we've talked about it.
May I? No, at this point, the objection mainly is just to, I don't know, can you hear me?
Yeah, loud and clear.
Okay. I think at this point, because now it is the first petition, now the main objective of such an application will be to disqualify Ronaldo, from petitioner and being listed as a petitioner in that application for letters of administration, so that now Ronaldo, the two kids can come in and put in a fresh application, as the persons who are qualified to do such. So the main objection actually is to disqualify Ronaldo as a petitioner for letters of administration at this point. That's what I think. That's the main objective, actually, why we'll be doing this.
Nicole, what do you think?
I'm not too well versed in this topic, so I don't have an opinion.
Yeah. So I think,
because remember, the first, when you petition the court, usually petition, when you do the first petition, it's usually for purposes of collection and preservation, where you'll be issued, if everything is okay, you'll be issued with a temporary grant for collection and preservation of the estate, awaiting now the confirmation of the grant and all that, after the hearing and all that. But at this point, now we want to disqualify. I think that's the main objective, actually. We found out that he's not her husband, so he shouldn't even be there. He shouldn't be petitioning, he shouldn't even be petitioning that to the estate, as a beneficiary to that estate. So the main objective actually is just to disqualify him from that application.
Any other
Hello,
opinion?
Edward.
Yes, sir.
Yeah, I'm looking at the question.
Yeah.
The children, that is Maradona and the other one, they are both worried that they may be locked out of their mother's estate since they are not included in the petition. So at this point, what do they want? What are they worried of? They want to be included. So I think the objective here is to make sure that they are included in the petition as the children of the deceased. And in the objection proceedings, therefore, it really meets the grounds that I think were earlier stated. One would be maybe concealment of the beneficiaries, that is a ground, and then lack of consent from the beneficiaries who are also capable of petitioning for letters of administration. So that is how I'd look at it based on how the question is directing us. Because if we bring the argument of whether Ronaldo is a legitimate husband of the deceased, then I don't know how we would answer question C. Thank you.
Welcome. So guys, we have those three issues that we need to consider. Before you answer that question, we have to consider whether our application is to make reasonable provision, or our application is to add these guys in the petition, or our application is to actually disqualify this particular person as administrator. Okay. And if you look at section 51, which talks about application for grants, and if you look at 51.2, it says that every application shall include the following information: the full names for the deceased, the date and place of death, the last known place of that, the relationship, if any, whether or not the deceased left a valid will, the present addressees of the executor appointed in any cases, and the children, and all that, a full inventory of all the assets. And if you look at 52, it says that any person who, in an application for representation, willfully or recklessly makes a statement which is false in any material particular, shall be guilty of an offense and liable to a fine not exceeding 10,000 or 1 year jail term. Now, it doesn't talk about the fact that if you leave these people out, then that would be a problem. But I'd implore us to look at the act. It talks about disqualification. Please, if you get time, look into disqualification. For what reasons would we disqualify a representative, an administrator? For what reason? And maybe that would come up later, but can it also come up at this particular period? Now, I want to leave this question open. It's one of the questions that, again, we'll talk about when we talk about the question that we talked about earlier on, the one that talks about the fact that the person has to be present. So I want to give you guys time to just look into it, so that we decide what is our intention here. What are we really going for? Why are we making this application? Explain whether Ronaldo is a husband of the deceased for purposes of succession. It's 2 marks. Anyone with a quick answer? Yes, Nico.
Yeah, he's not a husband for the purposes of succession, and this is informed by Section 6 of the current Marriage Act, the 2014 Marriage Act. So it states the kinds of marriages which is civil, Christian, Islamic, Hindu, and a civil marriage, and obviously the customary marriages. And since they were still involved in the preparations for fulfilling the traditional rites of dowry. Obviously, at this point, a traditional marriage had not taken place, and this can also be shown through the fact that the question doesn't state anything about the token payment of dowry that's required to sort of prove a customary marriage. So he's not a husband for the purposes of succession.
All right, but someone again would argue that these people are cohabiting together, and maybe Hortensia, Yahweh would apply here.
I don't think it meets the requirement for over a long period of time.
Have we disclosed the period?
No, but considering that she was making the will in the will that was invalidated in 2020 and she died in 2021, that's only a period of about 2 years. So I don't think it qualifies for a long time period.
Yeah, but you have to remember by then they were already dating. So it's not like they started dating in 2020. They were dating even before that.
True, but even then, okay, I don't remember the full citation of the case, but there's a Nyambura case. Okay, the Nyambura case, I'll look for the full citation, but it states that there must be consent by both parties to create a marriage. And you could argue that by them undergoing through preparations to sort of formalize it in a traditional wedding sense, they didn't intend to create a cohabitation relationship or the presumption of marriage.
Okay. All right, we can say that. Any other different answer or opinion before we call it a day? Okay. Now, I've always found probate questions really open, and it really depends on how you're going to support your answer. Someone would go with the fact that these guys are cohabiting and this and this and this. Someone would say what Nicola said, that even if that was the case, there was no intention, because later on you realize that they wanted to actually formalize the marriage that they had. So they actually knew that there was no marriage. But again, someone would again argue, but cohabitation is not marriage. Cohabitation is presumption of marriage. Presumption of marriage and marriage are two different things. We are presuming. Presumption of innocence and innocence are two different things. If I'm presuming that you are innocent, it just means that we have not proven that you are guilty. If you're presuming a marriage, it's just because we have not proven that there's no marriage. But anyway, question for another day. So in my opinion, I'm thinking you can go for the two, but you really have to defend whatever you go for. And these questions are really, really open. Yeah. But if you go with, I'd go with the fact that they were not married. But if you go with the fact that they were, then you'd really have to be careful to ensure that you meet all the provisions of whatever is required to prove presumption of marriage under Hortensia Wanjiku. Yahweh. Okay, that's it from me, unless we have another question coming from someone else. But I'd really like it if we call it a day, guys. Any question from anyone? I know we haven't done question 5. We'll do it in our next discussion for probate. Now, even as we finish, one thing that I really like from you guys is the fact that we had people participating, we had different answers, we had different perspectives here and there. And, for us really, our intention is just to bring you guys together and to have us share our opinions on these matters. I want to believe that just from hearing from us during this revision, probably there's something that you've even had no idea about. But these things come in and you hear people talking about it, you get curious, you look into them, people come in with different perspectives, you get curious and try to understand how they are thinking and why they're thinking like that. And that helps us. It helps us to open our mind, it helps us with our revision. So really, our intention is not to ensure that every single time we discuss a question, what we're looking for is the right answer. What is the right answer anyway? Of course, we also have wrong answers. Okay, so we really want to just bring us together, have us discuss these questions, have us think about this question, have us try our best to answer these questions, have us come with different opinions, different perspectives, open our minds and see how these questions can be answered, and actually believe and understand and see that this is actually possible. Now, at this first part of our revisions, I know it's going to be answer here, answer there, answer here, answer there. But as we get closer and closer to the exam session, we're even going to share how are you actually supposed to answer a question. Because again, you can't give 5 answers and expect to get results. I mean, if there's even no time, so what really can you go with and what is really important? So I'm really glad that we have different answers. I'm really glad that we have different opinions. As we grow, as we move, as we get closer to exams, we are going to discuss actually now how to put those answers into practice, how to write those answers in our opinion. Please don't sue me for negligence if this doesn't work, in our opinion and what we think can work. But mostly we just want to have us discuss this and know that we can actually do it. It's not life and death. We can do it. We're able to discuss these questions. We're able to get the answers. Guys, it's not a hill that cannot be climbed. We can do this. So I'd just like to encourage you guys, when someone is giving a different opinion, when someone has a different, just listen. Just listen. They could be right. They could be wrong. But just listen to what they're saying. You could learn something that you actually didn't even know about. For example, today when we talked about, someone being present and all that, honestly, from me, I've never seen those cases. But yeah, I mean, today it came up here, and we're talking about the fact that this person has to be present. Now, the act doesn't state it, but it's a good opinion that now we have it, that now we'll think about it, that now we're going to dig in and do our own research so that we know the right answer. It's just important through this session. It's important that we get to do that and our minds are open. So I want to thank you guys for participating. I want to thank you guys for being present. I want to thank you guys for, opening your mind and your eyes and ensuring that we are able to sit here for close to 3 hours, and for the energy and for putting in the effort. I know at one day and at the end of the day, this is going to bear some fruit. It will bear some fruit. So let's just keep going. Let's just keep pushing. Do not lose the motion. Do not lose the energy. If today you learn that you do not know this, please, that's a chance to do your research and get to know it. Do not lose hope. Again, nobody knows everything. Nobody knows everything. We get to learn through things, through research, by reading. Sometimes you only get to learn about something by not knowing it. In fact, if it wasn't brought to your attention, and if you didn't realize that you didn't know it, then maybe even you couldn't even have learned about it. So it's fine. It's okay if you get a question that you cannot answer. If someone gives an answer that you don't even understand, you've never heard about yet, it's right or it's wrong, please. This is the time to be curious. This is the time to research. This is the time to get ready. So let's get ready and let's just hear each and every answer. As we move on, we'll trim them and put them in the right places. Anyone with anything to say before I pray and close? All right. Again, Julian, thank you so much. Thank you so much for projecting the work for us. Thank you. Thank you so much. Thank you so much for that. Pius, would you like to pray for us today as we close? Or we can have Lim, or we can have Nicole, anyone really. Or Julie, or Jerry Jane, or Hillary, or Barack, anyone. Yes, Chelsea, go ahead.
I can go ahead.
Yep.
Okay, let's pray. Almighty and ever-living God, thank you so much for this session. Father Lord, I pray that, oh God, what we've learned may stay, oh God, in our mind. May you help us, God, in the coming examinations, that we may be able to remember all we read, all we revise, and help us get all the 9 P's. As we go to sleep, Lord, protect us and be with our families. In Jesus' mighty name, I pray, trusting and believing. Amen.
Amen, guys. Thanks so much, Julian. Guys, have a good night. I'll share the recording. Let's keep going. Let's keep moving. Again, you can do it. You can do it, man. This is possible. Bye, guys. See you again next time.